condition is while boarding the cruise, you have to mask 6 months validity of the passport. I applied for the renewal. My renewal has been withheld only on the ground that my name has been deleted to this process. But I filed an appeal. It's an extremely urgent matter. Unless
what appeal? SR appeal.
Yes, madam. They have given deadline of 26th July. Before 26th July, if I could not submit the renewal of passport, my service will go.
Under compelling circumstances, my lord,
No mentioning
it's an international maritime matter. The only difficulty, my lord, it cannot wait till the next Monday. I'll indicate why. My lord, it's an international maritime matter. It is our goods, my lord. It was carried by a it's shipping line which got stuck in the Iraq war. My lord, in the port of discharge, my lord, it is stranded. My lord, the mediation meeting has failed. My lord, it was ongoing. On Fridays, the next date, it will be moved on, my lord, Monday. In case, my lord, the report comes, it will be moved on Monday. This writ will become infructuous. We have, my lord, only prayed for a direction on the DG shipping that implement your own circulars. They have circulars in place, my lord.
What is a prayer?
My prayer is, my lord, a prayer on the DG shipping that they should implement their own circulars against the shipping line agent, my lord, which is in Calcutta. My lord, today, if they don't do that, every day, my lord, the shipping line is, my lord, the goods, the owner of the goods is incurring more than, my lord, 10 lakhs a day. This is the, my lord, extreme urgency. Today, my lord, if that does not happen,
so what the circular says?
Circular says that you cannot impose this war surcharge. They have imposed war surcharge of $800.
Imposed the war surcharge.
My lord, the shipping line. That they cannot. That's the circular which says this. And we are only praying, my lord, a direction. We have made a representation, no, my lord, consideration by DG Shipping. Only a prayer that DG Shipping be directed to implement their own circulars, nothing else. And to consider a representation, my lord. Otherwise, my lord, we will not know our fate by Monday.
Where it can be fixed?
My lord, it will not take us more than 10 minutes, my lord.
Maybe, but my diary is totally
I understand that, my lord. I'm sorry. Under extreme compelling circumstances, I'm mentioning this, my lord.
And 23rd.
23rd, my lord.
Can be.
Lordship.
23rd within 10 minutes.
I'm very deep.
Very compelling circumstances.
No.
This is your lordship. Kindly just hear me once. Lordship will hear me once, your lordship. Your lordship unilaterally always imposing. Your lordship. Lordship will kindly
Come tomorrow. SIR matter Friday. Yes.
For inclusion, my lord,
I am appealing for the petitioner, my lord. My entry order is expiring today.
my lord, SI matter for inclusion, my lord.
Come tomorrow. Friday,
my lord.
Come tomorrow. Tomorrow is the mentioning date. Whatever the SIR matter, my lord. Let will see. Yes. Most for the other side.
My lord, my friend, my lord, is appealing.
No, you are, my lord, submitting, my lord, PDP. PDP in opposition.
There was a direction.
Copy has already been served.
We have received the copy, my lord.
Date may be fixed.
My lord, we have also prepared our reply.
Copy this.
Copy this. Copy this. যদি না পাও তা বলো
Yes.
we are submitting our reply
পাইনি আমার দিয়েছে না ওকে দিয়েছে
জানি না
না পাইনি
তুমি নো
Yes. What about the can? Have you served the can?
yes milord can milord is for extension milord that was
The entry mode is still today.
till today
By which order?
my lord previous order my lord has only extended time to time my lord sees
By which order they extended till today?
last order my lord
22nd July.
yes
Yes. What about this entry mode?
Maybe extended, my lord. Date may be
The
short date may be.
Respondents have filed affidavit in opposition. Petition has filed reply to the opposition. Let the same be kept with the record. Petition has filed an application being can 1 of 2025. 2025. Key. 2025.
Milord, can one maybe milord dispense with milord recording infractions
Counsel for the petition press that the entry mode is still today and entry mode press for extension of entry mode. This court find that the pleadings have been completed and matter is ready. Let the matter appear on.
any day my lord fixes
Let the matter appear on on 25th of August 2026 under the same heading. Under the heading hearing, interim order is extended till 26th, na? 25th of August 2025 or until further order, whichever is earlier. This court finds that the petition one can application is pending, praying for extension of interim order, but this court that interim order has already been extended according can 1 of 2025 disposed of.
One thing, my lord, may I just suggest, my lord, that interim order be till before the vacation? or other-
Next,
mentioned by-
নামটা দিয়ে দিয়েছি।
To answer the
Dada.
question, your lordship, I'm praying for extension of the interim order, which is valid till tomorrow, your lordship.
In this matter, I mean, applying for the Bajaj Finance Limited, till date we have not received the copy of the petition. Kindly direct,
Served. We have
kindly
served
direct them
again,
to
sir.
pass the necessary
served
to so that
completely
the
served.
petition can be served upon us, my lord.
May I indicate, your lordship, the direction was for 2 weeks and 1 week for filing of opposition and rejoining.
you're appearing for
Bajaj Finance Limited.
Huh?
Bajaj Finance Limited.
respondent number?
My lord, till date we have not received the copy, my lord.
Respondent number? Bajaj?
Bajaj Finance Limited, my lord.
Respondent number 6, your lordship, we have again served. We will again give a physical copy if required.
My
Six has not appeared on the last occasion.
Yes,
also.
yes.
So the
But
copy.
after that, they had, we have served. Affidavit of
so.
service. Will serve.
Give one copy.
Yes.
Your Lordship, I appear for SDFC Bank. I'm praying for short extension of time for filing affidavit in opposition. My lord, it's ready. It's required to be affirmed, my lord.
Yes.
So the initial
That is
direction
fine.
for affidavit was 2 weeks plus 1 week for rejoinder.
Hmm.
The matter is returnable on 4th.
Hmm.
So I'm praying for an extension of the interim order, your lordship. And only,
None have filed the affidavit. in
only
opposition.
opposition has been filed by SMFG, which is respondent number 17. That is the,
Opposition, we have responded number 17 here.
that is the only opposition we have received till date. None of the other respondents have filed.
One prayer, my lord, on behalf of the respondent number 7, my lord,
Hmm.
Lordship, may kindly extend the time for us to file the affidavit, my lord.
Except the respondent and respondent number 7 has filed affidavit in opposition after
Your
serving
Lordship, I'm appearing.
petitioner. Let the same be kept with the record. The other respondents have pressed for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply if any there to be filed within a week thereafter. Counsel for the petition submitted the interim order is still today and paid for extension of interim order. As the in view of the submission made by the petitioner, interim order is extended till 27th of August 2026 or until further order whichever is earlier, let the matter appear on 27th.
I'm deeply obliged. Interim order is till tomorrow, your lord.
Yes.
I'm deeply obliged.
Next.
My lord, in item number 3, I'm for the petitioner, my lord.
Yes.
This is a group 9 SARFACI matter, my lord. On Monday, this matter was mentioned before your lordship only for seeking its release, my lord. Due to some inadvertence, my lord, it has come up as for withdrawal. I'm for Punjab National Bank. my lord.
This has to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petition submitted the matter is connected with the SARFACI Act. According, she prays for release of the matter from the list of this court with the liberty to mention before the approval court having determination.
I'm grateful.
In view of the submission made by the counsel for the petition, WPA 14261 of 2026 released from the list of this court with the liberty to the petitioner to mention before the appeal court having determination.
I'm grateful.
Next. May it please the court. I beg to appear on behalf of the respondent numbers 6 and 7. Yes.
Well, 7 could not have been a proper party. It ought to have been commissioner of Kolkata Municipal Corporation. Mayor does not do any.
We'll do that correction, my lord. Lordship will grant. My lord, very short. I'll be making a very innocuous prayer, my lord.
Yes.
Let them file a report in
Who
the
will
form
file
of an affidavit. The KMC.
Why should I? The deed is, your lordship kindly comes to paragraph 15 first. And the prayer,
My application,
prayer A.
if he has to make submissions, then
Because if you are asking for something which is unsustainable, corporation will investigate and give a report. What investigation
But
will
my
happen when the
representation-
deed is fraudulent? The police has to do it,
my lord, my,
engineer has to do it,
my lord,
corporation role is far away.
my lord, my
Yes,
representation
what
is.
is the prayer? What is the prayer?
My lord,
See-
my prayer is, my lord, that the report should be filed and thereafter, my lord, action to be taken. My lord, lordship kindly comes to page 99, my lord. Page 99. 99. Annexure P7, my lord. A representation dated 6/12/2024.
Yes.
Lordship sees the heading, forged general power of attorney manufactured by so and so.
If it is a false document, why corporate?
We made the complaint to whom? To the Inspector General of Registration, the DR, the KMC. Now, my lord, what did we pray, my lord? Lordship will kindly come to page 101. Because a forged power of attorney has been used to register a property and develop the property, my lord. Therefore, my lord, now your lordship will kindly come to page 112, my lord. On the basis of our complaint, my lord, a letter was written by the additional IGR to the DR.
Yes.
This report has not been forthcoming. All that I was beseeching, my lord, let them file a report before your lordships in the form of an affidavit. And not since KMC has acted on the basis of that forged power of attorney, they can also file a report subject to what falls from my lord.
So if there's a forgery, why you not made a complaint to the police? Or
We have made a complaint. That complaint is pending. But my lord, here, my lord, the IGR is the authority who is to look into the matter and find out what has happened. Because all the records are with them, my lord. Lordship will kindly therefore direct them to file an affidavit, my lord, in the
who is
form.
appearing for the estate? Who is appearing for the estate? You are appearing.
No, I am appearing for the Kolkata Municipal Corporation.
Who is appearing for the Inspector General?
I do not.
We have served. We have served.
We do not.
Copy diyecho.
That is the problem. Yesterday evening they came here. Yes, they will appear. All will appear.
That is happening in the other courts also. And the courts are getting annoyed that we are not represented.
Yesterday, the GP has come. Other learned trial. The penal advocates came. Given because I passed an order for appearance of the principal secretary. When I pass an order, all has come.
All have come.
No, yes, from tomorrow, all the persons will go. No, again, the same thing is happen.
My lord, lordship will pass this order, my lord, and
Hearing for corporation, I want to just say with the deepest respect and utmost humility and the deepest respect to my learned friend was all this time.
Always the respect to each other.
Yes, my lord, he was very vociferous, saying the deed is fraudulent. Fraudulent. My lord, somebody has to declare that deed to be fraudulent. And it is only after the court with appropriate jurisdiction declares that document to be fraudulent. My lord, the first person is the IGR and the registering authority.
yes, that's what
You have registered the allegedly fraudulent deed. Now that fraudulent deed was ultimately utilized before the corporation to get the mutation. So once that deed is declared by the competent court to be a fraudulent one, then my lord, my action comes. My lord, his representation to the corporation with the deepest of respect I submit is premature as on date. Let some verdict be there that this deed is fraudulent. Then can I proceed? What affidavit do I give today? What report do I give to my lord? I ask a question to myself.
But for now, my lord, it would be in the best interest, my lord, that your lordship directs the IGR to file a report before my lord.
That's correct. I do not raise any objection to that. That is correct. Whatever
Right
my
of service,
learned friend is saying.
none appears on behalf of the respondent except the respondent number
Lord KMC is the
6
respondent number
and 6 and
But
7.
7 has to be
My lord, leave be granted so that
Respondent number 6 and 7. 6, 7 and 11. Police. Learned counsel for the respondent number 6 submitted. The petitioner has made the mayor of the Kolkata Municipal Corporation as party to the presented application, but instead of mayor, it should be a commissioner Kolkata Municipal Corporation. Accordingly, counsel for the petitioner prays for leave to correct the cause title of the respondent number 7 by deleting the mayor and add the commissioner, commissioner Kolkata Municipal Corporation. Leave is granted, petition is given liberty and leave is granted the petitioner to correct the cost title of the respondent number 7 in course of the day. Full stop. The petition has filed after full stop. None appears on behalf of the other respondent in spite of service of notice. The grievance of the petitioner in the present date application that the petitioner has made a detailed complaint to the Principal Secretary Finance, Inspector General Registration, District Registrar, Additional District Sub-Registrar and Kolkata Municipal Corporation with regard to the forged general power of attorney manufactured by one Amitava Basu. Is the respondent number Amitava Basu is a party here?
Yes, my lord.
No.
My lord, additional lists have 4, 4, 5.
By one Amitava Basu.
They are additional is 3, 3, 4, 5.
Amitava Basu and with the help of with the help of respondent number 8 and one Sanjay Basu respondent number 12. The petitioner on receipt of the complaint of the petitioner, the additional IGR and additional CSR within bracket registration within bracket WB dated 25th of March 2025 directed the district registrar South 24 Pargana to cause inquiry and to submit detailed report for taking appropriate action. But in spite of the said communication, no report has been filed. This could find that before going into the merit of the case, the respondent numbers
2 onwards. 2, 3.
Number 2, 3, and 4 are required to file the report with regard to the complaint made by the petitioner dated 6th of December 2024 and the communication made by the
Additional IGR.
respondent number 3 to the respondent number 4 within a period of 2 weeks from date. Let the matter appear on 11th of August 2026 under the same heading. The petition is directed to communicate this order to the respondent number 2, 3, and 4 for compliance.
As also, my lord, the learned government pleader's office, my lord, will do that also.
As none appears on behalf of the state authorities, the petition is informed to and directed to inform requested and directed to inform the next date of hearing to the office of the government pleader.
I'm grateful to you. 11th August. My lord, fairly at the top. 11th August, fairly at the top.
Within 10 matters.
I'm grateful. Grateful, my lord.
5 is appearing.
I appear for the petitioner, Lordship. This is the.
I'm appearing.
Yes.
Your Lordship.
Sorry, yesterday I couldn't reach in time.
The state has been served thrice, my lord.
Yes, I'm appearing. For 6.
Only report has been filed by respondent number 6, my lord, and whatever contention made therein is, my lord, that includes the events which happened prior to the order dated 24th April 2023, my lord. While passing that order, the Honorable Division Bench took into consideration all these events. That committee was formed for the payment of dues to the investor of the bank, my lord. But considering all these aspects, the Honorable Division Bench passed a direction upon the state government as well as the authorities to consider the dues of the employees of the bank so that
they are appearing for the bank.
I'm not appearing. Nobody is appearing for the bank because bank is defunct. I'm appearing for a committee which was formed to pay the depositors.
only that committee made the payment towards salary and all, till the bank was alive. From July 2010, the bank is not functioning because of the license was not granted by this one. The prayer for license was rejected by Reserve Bank of India. So the bank went into this one. It cannot function without a license. So my first prayer would be that even if the dues are there, even if the Honorable Court has passed an order paying payment of the dues, that dues would be limited to the time they were working. They have annexed their claim from 2010, July afterwards.
When the bank was closed.
July 2010.
July 2010, the bank was closed.
Yes.
Correct.
That is the admitted position.
Correct.
After that, if you are not working, how the bank was then not in a position to give any kind of work to the employees. And the employees virtually, I will say the employments.
Who is appearing for the state?
I am attending.
Yes. What is your instruction?
Practically, my lord, I am in dark. I have
You are
no
in dark.
instruction.
Come on, white.
Grant me some time for a week.
Come out from the dark first. Why you are remaining in dark? Come out from the dark.
No, without instruction, I cannot.
My lord,
My lord,
has been
kindly
Because
grant me
you are additional chief secretary directed to file their individual claim.
Yes.
They have filed the individual claim. What has happened to that?
That claims have been disposed of by the only authority which was functioning with a limited power. That is my client.
Who are you?
I'm the respondent number 6.
It has not been disposed of, my lord. That is incorrect.
So,
No.
show me the, okay, you file the report.
I'm showing you this.
Disposal.
This thing is that the gentleman is not there. He has retired. So I want to file this one. New officer has been appointed to head the chairman. That copy I have already given. Ajay Ram is the new this one. There is new committee formed as per order dated 2/2/2026. And that gentleman retired on 31st December 2000, but he filed a report in compliance of your lordship order.
So this is a committee constituted.
Fresh committee.
So you are telling that they have considered the complaint of the petition. Where is that consideration? Kindly come to the page.
Payment of gratuity is there.
Kindly come to the. Yes.
I have filed a report.
When you have filed that?
I filed a report on the last occasion, my lord. I have filed a report. A report in form of affidavit, respondent number 6. I filed a report. Copy has already been handed over. They have taken exception also.
Respondent number 6.
Yes.
Yes.
My lord may come to 62, page 62.
62
of R15 of my report.
Page 62. Your report containing only 5 pages. Respondent number.
That is exception, my lord.
That is exception. My report is this book.
Yes, 62.
Yes, my lord. May I read? The actual employees of Ramakrishna Cooperative Bank place demands of rupees 1,46,23,594. 14623.
14 crore 62 lakh 35,000.
Yes.
Yes. Then.
But the AMC in the meeting unanimously decides that it will be paid to them as the law permits, as the bank ceased to operation on 2/8/2010. They will be paid area salary up to that date, up to 2/8/2010. And in the instant issue, salary for the entire month of July 2010 and for 1/8 and 2/8. For the payment of gratuity, same notion will be applied and the gratuity will be paid as it stands on 2/8/2010. Therefore, area salary up to this one be paid as a whole it stands. It transfers from the demand of the erstwhile employees of the Ramakrishna as endorsed by the manager. It is found that a good number of erstwhile employees have outstanding loans to the tune of 25,82,589 as a whole, and it is decided unanimously that this outstanding loan be recovered from them as per provisions of the law and book before making the payment to them. So these were the two conditions. They
Then-
recovered the loan and they paid. Next page is, Your Honor may kindly see. Annex, Your Lordship may kindly see. Annex R7, their statement of individual gross salary.
Yes.
And here their comments are written. Most of them have accepted, some have refused.
Where is the name of the petitioner?
Name of the petitioner is Sishendu Mitra 27 at serial number 27. One of the and the other is 36 Sanjay Patro.
This is the petition, 36.
36 and Sishendu both are petitioners.
Salary due.
Sishendu has not accepted and Sanjay Patro loan dues.
Not accepted. Loan dues. Yes.
Six is somebody's else name is appearing.
Yes. Yes, madam.
And for the gratuity, my lord, come to page 80, annex 18, page 68. Sishendu Mitra has received his gratuity.
Gratuity. Susan, where is
Only
Where is-
Sanjay Patro has not
very-
refused his gratuity as well as
where is the name of Sanjay Patro?
Sanjay Patro has refused.
Where it is?
It is not there since he did not receive the gratuity or this one. It is not there.
His name is there.
His
Not-
name is not
not
there.
there.
But the second petitioner's name is there. Sishendu Mitra. He received the gratuity.
Serial 28.
Serial 28.
Yes, 47,159. Yes. Then
So, Your Honor, this is the way. Your Lordship may consider this is the way the whole matter has been dealt with. But then the bank cannot be represented by anybody. It is their own admission. It is their own admission. They
Yes,
don't know who
madam.
is representing the bank.
Your Lordship, first of all, this by order dated reason order dated 26/11/2024, my lord, all the employees were asked, called upon by the additional chief secretary to present their individual claims, my lord. Now this order or decision, what my learned senior friend is placing, my lord, first of all, this has been passed by a committee, not by the additional chief secretary. That too was never communicated to the
but the
petitioner.
committee was constituted.
Your Lordship, all these happened prior to that. This committee was constituted only to take depositors, to pay off the dues of the depositors.
No, depositor, they have considered all these things with regard to your salary, because if the bank is closed from 1st of October, August 2010, if the bank is closed, how the salary can be made? Who will make the salary?
Your Lordship,
First thing. Second thing, the arrears and the gratuity, they have considered arrears. You have a bank loan, the bank loan is to be recovered. With regard to the gratuity, one of the petitioner accepted, one petitioner has not accepted. What remains
yes,
further?
my lord, I'm coming to that, my lord. First of all, my lord,
Lordship.
they have deducted the amount from the gratuity, which they, as per the law, cannot deduct. The loan cannot be deducted from the personal loan, cannot be deducted from the gratuity, my lord, which is illegal, my lord.
Not
This-
gratuity, that is the arrears.
They have deducted from the gratuity, my lord.
What is the prayer? Kindly come to the prayer of the writ petition. Have you challenged that? Have you challenged the deduction of the gratuity?
Yes, my lord, we
Where is that?
accepted
Which
with
prayer?
objection.
Which prayer?
Lordship,
Just a minute. Which prayer of the writ petition you challenge the
Your
gratuity?
Lordship, I have
Deduction of. Please show me which prayer you will challenge the deduction of the gratuity. Which prayer?
Your Lordship, I have in prayer, I have not.
You cannot change your
No, my lord.
argument, madam.
In,
You
in
have to-
pleadings, in pleadings, I have stated.
Where is the prayer?
In prayer, I have asked for consideration of my entire dues because my lord,
They are telling that they have considered, they have filed the report.
my lord,
The
this
committee constituted by whom?
by
Who has constituted the
by
committee?
the honorable direction of the honorable court, my
Then-
lord. But this committee was constituted much prior to passing of the order dated 24th April 2023, my lord. Had it been so that the no amount would be payable to the except the gratuity amount, the honorable court would not have passed a direction for consideration of the dues of the employees, my lord.
What is the direction? Show me.
Yes, my lord. Kindly come to page 20 of my writ petition, my lord. And furthermore, there was a direction upon the state to take steps for revival of the bank, which the state has failed to do, my lord. The employees were not terminated, they were not able to find any other other service they could not find because they were not terminated. Their service did not come to an end and they were restrained from doing any service at bank, my lord. Then what is the fault of the
The
employee?
bank is not there, the where you will do
My lord,
it.
my lord, this was the obligation. If my lord only comes to page 27 of the order first, my lord, the state government undertook to take steps for the
Where is
revival of
that? Show
my lord,
me.
kindly come to page 27 of my writ petition.
Yes. Show me which paragraph.
Yes, my lord, I'm coming to 27, my lord. I'm reading the relevant paragraph, third paragraph of the order. Page 27.
Yes.
We are conscious of the fact that the Reserve Bank of India has rejected the application of the bank in question for license to carry on banking business. This was way back in 2010. Now the state government has come forward to take up the entire responsibility of reviving the bank.
Now, can't you come to the page 28?
Yes,
Page
my lord.
28, last second paragraph. The state government shall also ensure that the employees of the bank receive their dues,
Yes, my lord.
which they are entitled. Yes,
Yes, my lord.
which they are entitled, they have considered. What further remains?
They have, my lord,
They
this
have not
individual,
worked.
they have gratuity amount has been deducted, my lord.
They have not worked. How they can claim?
It was
Yes, what you are telling?
personal from gratuity cannot be deducted, my lord. That is
State.
totally.
What you are telling? What is your submission?
I don't have any submission, my lord. I have to take instruction in that.
Okay, take instruction.
Yes.
Come with the instruction whether these
Absolutely.
petitions have been paid or not, or whether any dues are pending.
Absolutely.
The
Fortnight time.
Senate
having
Council
granted.
appearing for the respond number. You are appearing for the respond number.
I'm appealing for respondent number 6.
Respond number 6.
The
6
chairman.
has some.
The chairman.
6
committee.
has submitted the report. And submit that the committee has considered the case of the petitioners and have ascertained the entitlement of the petitioners, wherein it is found that the petitioner number 2 is entitled to get an amount of rupees 117,517, being the salary for the month of July 2010, but the petitioner refused to accept the said amount. As regard the petition number 1, the committee found that the petition number 1 is entitled to get an amount of rupees 14,546, being the salary for the month of July 2010, but the said amount has been recovered due to has been adjusted as on the loan dues of the petition number 1. The respondent number the respondent number 7 bola na? The respondent number 6 has further submit that with regard to the gratuity, the petition number 2 has received the amount of rupees 47,159, but the petition number 1 has refused to accept the petition number 1 refused to accept any amount. London Council for the petitioner submit that the state has not considered the case of the petitioner in terms of the order passed by the Honorable Division Bench of this court by an order dated 24/4/2023 in amity number 13-1387 of 2012, wherein the Honorable Division Bench of this court directed the state government to ensure that the employees of the bank receive their dues, which they are entitled to in accordance with law. Land Council for the petitioner state respondents prays for time to take instruction. Accordingly, case adjourned. Let the state respondents file report by way of an affidavit to indicate whether these petitioners are entitled to get any further amount. Let the matter appear on 20th August 2026.
20th August.
2020.
Lordship.
Next,
Lordship, may I file exception to the report, my lord? A prior
Exception
copy
filed
be
on the
given to-
petition be kept with the record. You not filed?
No, exception to respondent number 6, the state.
Let they file, let me see. Yes, next.
Lordship, in item number 6, short pass.
Yes,
Petitioner, my lord,
yes.
explain the contention of the particular report.
What report?
My lord, this is the report which was filed on, report dated 15th July 2025.
Yes.
Writ petition challenging the cancellation of the tender.
Hmm.
My lord, the tender was cancelled
Hmm.
on the basis of the resolution taken by the tender authority
Hmm.
on 20th May 2020.
Where is the cancellation? Where is the cancellation order?
My lord, there is no formal order, my lord. There is only a resolution, my lord. That is at page 43 of my writ petition,
43 of the writ petition. Yes,
a smaller one.
yes.
And my lord, it will be appearing, there are the 4 bidders.
Where is the decision? The court paper possessing Mr. Nihar Ranjan Paul as secretary of the so.
Then, my lord, come to the page 140, only 45. So it is also recorded in the house that existing tender to be cancelled as the member qualified bidder is less than 3.
Yes.
My challenge is that the particular L1 bidder whose bid was rejected after declaring the financial bid is ex facie illegal, and the observation made by the particular in the particular resolution is in contrary to the law. Milord, I am coming to the report is the crux of the entire resolution, Milord, and resolution is written handwritten, Milord. It will be much legible to go through the report. And Milord, and the report earlier filed by the earlier state advocates, learned state advocates, and the present learned advocates are similar. The Milord, I am coming to the point 1.
Where is your trade license?
Milord, I am coming to the one by one of.
Yes, show me the trade license. I am putting
Yes,
the question.
Milord,
Show me
that's
that
page.
because first discrepancy is the trade license of the petition certificate number so and so so and
Yes,
so.
Milord,
It's notarized document and so and so. Yes.
Yes, I have already uploaded the tender document, Milord, which was filed before the authority, and trade license is at page 38.
Page 38.
Yes.
Food service caterer.
Nature enterprise dealing with food item category.
So this is in the name of the United Order.
Yes.
Who are you? You are also United Order.
Yes, I am the United Order, my lord. Kindly come to the, this is B United Order and Supply Cooperative Society Limited. The writ petitioner hearing. Then second, my lord.
Just a minute, information. So what is their objection? Trade license issued by the petition certificate number so and so dated 9/12. Same thing.
No, they are referring the trade license is a different thing, my lord.
Where's
Their
the number?
Contention is the trade license issued by the petitioner certificate number such and such 9/12/2024. List Nihar Ranjan as a secretary under United Order and Supply Cooperative Society Limited. However, notarized document submitted 88 notary number such and such, that is at page 133. My lord, I am coming. They are disputing that I was not the secretary.
133.
133. That is the same notarial certificate, my lord. That is 35A.
Which document you have submitted? 133 you have submitted, or you have submitted the page 38?
Page 38 is
not submitted.
My lord, page 38 is the document of.
I am asking one question. With the tender document, which document you have submitted? 133 or 44?
This includes 38 and 133 includes the bid document. Bid document starting, my lord, from page. My lord, bid document starting from page, I am telling your lordship. The entire bid document starting from page 10 and my lord, last
10.
Page 10, 10. 10 of my supplementary affidavit.
That is the problem with all of you. Filing writ petition like this, then filing the supplementary affidavit like this. You are making out the case in the supplementary affidavit.
Lord, this has happened after the.
Henceforth, I will not allow all supplementary. I will dismiss your all writ petitions. Clients come, within an hour, you prepare the writ petition, file, let the court will see. When the court will put the question, supplementary, supplementary, supplementary. And putting the burden upon the court.
This is the affidavit of exception pursuant to the leave granted by.
Yeah, that's why affidavit of exception or affidavit in reply, you are making out in few new case. What are the documents you will not submit? Where is the supplementary affidavit?
Supplementary affidavit, my lord.
See, supplementary affidavit is like this. And writ petition is like this.
Page 38 is the trade license, my lord, which was uploaded in the document, bid document.
Yes, 38.
Yes,
Of the supplementary affidavit.
of the supplementary affidavit.
38 the license.
License, trade license. That is related with the food item category.
But this is not a supplement. You have stated that writ petition.
This is supplementary, my lord. It is wrongly written writ petition because it is.
Who has affirmed it? Who has allowed this affidavit? How the commissioner has allowed this affidavit? Double writ petition? What is going on in the office? How the two writ petition is affirmed?
No, this is not the writ petition. This is supplementary.
Where is the supplementary affidavit? Neither in front nor in the back.
In the front, it is.
Can you see?
Affidavit of exception, my lord.
It's the affidavit of exception, not the supplementary affidavit.
Yes, affidavit of exception.
So what you written in the back page?
My lord, this is my mistake, my lord. This is mistakenly written there. My lord.
All the things will be mistaken only.
I beg your lordship's pardon.
Yes, page 38.
38 is my trade license related to the food items, my lord.
Henceforth, I am telling to the bar, I will not accept any supplementary affidavit. Only in exception cases I will allow. The habit of the bar is so. Within 2 hours, you are preparing a writ petition, filing with the two documents, and subsequently you are bringing all the documents by supplementary affidavit.
I apologize.
Yes, what is the number?
This is the number.
So this is a certificate, okay. So it is in the name of?
It is in the name of the United Order and Supply Cooperative Society Limited.
Correct. So what is their contention?
Their contention is that they're referring the different number. This is the petitioner certificate number 0917P302 9242067991 dated 9th December.
So where is this document?
My lord, this document not pertaining to this tender document, my lord. This tender document might be in other document, my lord, because we have applied in different tender, my lord. So this
No,
is.
I am asking whether the 7 surplus I, the document which they have mentioned,
Yes.
have you submitted this document?
No, I have not submitted.
Not
this, sir.
submitted. Okay, then leave it. Then
Yes.
come to the second.
Second, my lord, this my contention is that 38 page at page 38 is a trade license which is related to the tender document. Is a food item. Next, there.
Just a minute. Where is the second document?
Second document at page 133 of the said supplement affidavit of exception.
133.
33. Here, Milord I. Sri Nihar Ranjan Pal, son of Ramgopal Pal, aged about 51. This is he is certifying that he is the secretary of the United Order Supply and Cooperative Society.
No. Kindly come to the 7II of the report. Where is this document?
Mismatch in the trade license category.
Yes.
Trade license category, they are saying.
Where is your trade license?
Trade license at page 38. I have shown your lordship.
But the number is different.
But this is the item which
You do one thing. You bring the original tender
Yes.
document of the petitioner before this court. The respondents have filed the report wherein the following discrepancies has been mentioned in the tender document submitted by the petitioner. When the matter is taken up for hearing, the petitioner submit that the document mentioned in the report is not the document submitted by the petitioner along with the tender document. Accordingly, the respondent authorities are directed to place the original tender documents, original bid documents of the petitioner along with all documents which have been submitted by the petitioner along with the bid before this court on 30th July 2026. This is the matter on 30th July. Yes, who is for the 7?
Wait, please, Your Lordship. Lord, I concluded my submission.
I was addressing your lordship. This is regarding, my lord, the
One clause in the
validity
office
of
order.
clause 14.00 of office order number 2514 dated 8/9/2025 and form number 11 provided in the office order number 2518 dated 8/9/2025. Well, we have prepared a, well, borrowing the expression from Mr. Bach's skeleton notes. Kindly allow me, well, one correction is required to be made. May I hand up a copy of the skeleton for the lordship? Thank you. Na dao copy dao. Oda ki diye chalo. Well, may I just take your lordship through the notes?
Yes. Of your notes?
Yes, ma'am. Well, I have dealt with the notes of submitted by on behalf of the petitioner, Mr. Bach at last occasion relied on the notes. And kindly take, well, the subject matter of challenge is clause 14.00 of the office order number 2514 and form number 11. Well, I have quoted clause 14.00 at under the head impugn provision and the declaration form. Clause 14.00 provides that the bidder should submit a declaration as follows. The bidder should submit the declaration in prescribed format under form folder form 11 in their letterhead regarding no legal litigation against WBSEDCL is pending in any court forum against by the bidder or its sister concerned director, partner, proprietor. If any type of legal litigation arbitration against WBSEDCL is pending in any court, then the purchaser reserves its right, the right to reject the bid or termination of contract. Form 11 contained in the office order number 2518 dated 8/9/2025 provides that the following declaration has to be submitted by a bidder. But Form 11, my declaration regarding no litigation against WBSEDCL. We hereby declare that no legal litigation arbitration is pending ongoing against WBSEDCL in any court forum against or by the bidder or its sister concerned director, partner. If it is found at any stage of tendering, our offer will be rejected. We don't have any objection on the same. So, my lord, the declaration has to be given. And if any declaration is given which is apparently not correct, incorrect, then obviously, my lord, the employer has the right to reject the bid. Now, my lord, the submissions, if your lordship kindly come directly to this particular office order, which your lordship will find in the writ petition.
Which writ petition you are referring?
My lord, the second one, I believe.
1595.
Yes.
5195.
Yes, yes. Second one, I believe. Well, kindly take page 387 of the writ petition.
Yes.
It has been indicated in the policy why this particular clause has been inserted, and my lord, why this clause is sought to be invoked by the employer in case of evaluation of bids which may be submitted by the bidders. Kindly take, my lord, the subject. Amendment of clause 2.0 so and so, that is not relevant, and inclusion of so and so, and inclusion of bid under the new subclause 10.04, and litigation arbitration against WBSEDCL under new clause for number 14.00 in the revised purchase policy of WBSEDCL. Why it was introduced, why it is being introduced? In order to improve operational efficiency and mitigate potential litigation in view of the changed circumstances, it has been decided to make the following amendments and inclusions in the revised purchase policy of WBSEDCL. The clause which I have quoted, your lordship will find at page 389. I have quoted in my notes, so I am not taking your lordship to that. And the form which forms part of the another office order being dated September 8, 2025, your lordship will find at page, the form your lordship will find at 383. The office order starts at page 380.
So this is a declaration form.
This is the declaration form. Absolutely. So my submissions would be, first, the policy has been framed to improve operational efficiency and mitigate potential litigation as indicated in the policy itself. Now, to elaborate this, kindly take my submission number B in my notes. It is the respondent is obviously an electricity distribution company and is enjoined with a duty to render essential services to its consumers within its distribution area network. The present policy has been framed keeping in view the nature of essential services rendered by the respondent. But the tenders which are floated and where my learned French client is participating, intends to participate or have participated, these are essentially for implementation of infrastructure projects. Clause 14.00 has been inserted in the purchase policy or the procurement policy, if may use the term, to examine and assess the litigation history of the participants in the tender process and arrive at a conclusion at the stage of evaluation of technical bids as to whether award of contract to such bidders would facilitate the execution of the works or supply of goods or would impede. That assessment is required to be made at the stage of technical evaluation. And once the litigation history is provided by the tenderer or the bidder, the employer would be in a position to ascertain that if there is any potential, if there is a real likelihood of litigation in future. This is kind of risk assessment. Kindly now take, essentially this is an economic decision of WBSEDCL, which in my most respectful submission is neither arbitrary nor discriminatory so as to offend Article 14 and 19(1)(g) of the Constitution. Quickly, four judgments. Manohar Lal Sharma,
Then if Mr. Majumdar,
yes,
okay, we'll go by this. It is not offend the Article 14 and 19.
Right, man.
Suppose there are 50 contractors.
Yes.
Bidders.
Absolutely, man.
Who normally participates in the WBSEDCL contract. Correct. If suppose 50 contractor, out of the 50, suppose 20, 30 are the having the arbitration or something, money dispute or whatever it may be, or challenging the tender condition, whatever it may be. If it is so, then only it cannot be treated as a monopoly amongst the.
It is, my lord, it is the most pertinent question. My lord, I have to answer this. My lord, I was expecting that something would come from your lordship. My lord, absolutely, my lord, this is the apt question to put. My lord, may I answer it in this way? Suppose there are, my lord, 50 bidders. My lord, in case of 50 bidders, our 20 bidders are in arbitration or litigation with WBC, ACDCL. Now, my lord, it has to be seen while assessing the risk, this risk assessment, it has to be seen that out of these 20, my lord, this is for your lordship. My lord, it's not that the respondent has made up its mind. Out of these 20, whether these 5, 1, 2, or 10 are habitual litigants or not. So that distinction has to be arrived at upon consideration of the materials on record. If it is found, my lord, there are, my lord, 20 bidders who have, my lord, if we categorize that, they have 10 bidders have 1 or 2 arbitration pending, and 7 bidders, with respect to every contract, there is an arbitration or litigation pending. Then that risk assessment, my lord, in my respectful submission, subject to your lordship's kind consideration, that risk assessment, my lord, an employer, being, my lord, a public utility service provider, is entitled to take. Well, this is my understanding, humble.
But your condition does not say.
Well, the condition says, my lord,
Yeah,
condition,
with the assessment.
condition says that to overall, the exact words used in the policy are like this: to overall improve the overall efficiency and to identify the potential litigation. So when we are using the expression identifying or something, well, may I just use the exact expression?
But no, so clause 14 does not say that.
My lord, clause 14, my lord, I beseech your lordship, my lord, absolutely your lordship. I beseech your lordship, my lord, clause 14 has to be read in the light of the policy itself and the preamble to the.
It's not in that. So suppose.
Yes.
I accept your contention.
Right.
But this clause 14 does not say with regard to the taking into potential candidature of the person.
May I just read out
clause 14 directly dividing the persons either 1 or 2 or 10 or 50.
But
What are the cases pending against him? The total, either 1 or 2, or it is not that it will be considered.
My lord, subject to lordship's kind consideration, if we take the second paragraph of clause 14, if any type of legal litigation or arbitration, and this is the exact language, against WBSEDCL is pending in any court or forum against or by the bidder or its sister concerned director, partner, proprietor, then the purchaser reserves the right to reject the bid or termination of, reserves the right. It doesn't mean, my lord, it will be exercised, my lord, without having regard to, my lord, the nature of litigation and, my lord, whether the bidder is a habitual litigant or not. Reserves the right. The language is reserves the right.
Okay.
Yeah. So, my lord, this is my humble understanding. Okay. My lord, kindly, my lord, may I just quickly run through the cases under the head of economic policy, and your lordships have held. My lord has held time and again that economic policy, when your lordships are always circumspect to interfere with the economic policy so framed by, my lord, state within the meaning of Article 12. My lord, kindly take Manohar Lal first, para 14. 2013 6 SCC, 2013 6 SCC 616. On matters affecting policy, this code does not interfere unless para 14. I'm so sorry, my lord. I'm deeply sorry.
Yes.
Does not interfere unless the policy is unconstitutional or are contrary to the statutory provisions or arbitrary or irrational or in abuse of power. The impugned policy in that case allows foreign direct investment up to 51% in multi-brand retail trading, does not appear to suffer from any of those vices. Now the next judgment is, my lord, a judgment rendered by Andhra Pradesh High Court, as the High Court then was, my lord. This is, my lord, 2003 to APLJ HC High Court, Bhagyanagar Energy Telecom. May I hand? And in this case, my lord, the facts, it is indicated in my notes. In this case, the facts were like this. That policy decision taken by BSNL to procure cable jointing kits only from indigenous manufacturers from granule stage was held to be reasonable. So, my lord, a classification was made by the employer in its own commercial or, my lord, economic wisdom. Kindly take paragraph 10 to 12. My lord, 12, your lordship may kindly note, my lord, subject to your lordship's kind consideration, obviously. From the aforesaid decisions, it is clear that it is not for the court to go into the wisdom of the policy decision and judge its pro and cons and say whether it is beneficial or equitable and say it shall not interfere with the policy decision unless it is demonstrated and shown that the policy decision taken is capricious or arbitrary or is not informed by any reason or if it suffers from the vice of discrimination or infringes any of the provisions of the statute or constitution. Even if the policy favors a particular class of persons or individuals, the court shall not interfere if the policy seeks to protect the vital interests of the community and does not affect the economy of the country. My lord, it is the age-old principle. As my lord Cicero once observed, salus populi suprema lex. My lord, it is the supreme law that, my lord, the welfare of the people should be the supreme law. So, my lord, now, next judgment would be, this is extremely important, this is Bajaj Hindustan versus Sir Shadilal Enterprises. This is 2011-1 SCC 640. Kindly take from, my lord, what was challenged in this case. My lord, lordship may recollect in UP, my lord, several petitions were filed challenging the delicensing of sugar industry. It is that judgment. So, my lord, kindly take, my lord, from paragraph 38 to 46 rather. Well, 38, it refers to, my lord, the judgment rendered by Justice Frankfurter of the US Supreme Court. Then, my lord, 39, where the Honorable Supreme Court makes it clear it is not that your lordships will not interfere with any administrative decision. Obviously, my lord, the judicial review is only meant for that purpose. We should not be understood to have meant that judiciary should never interfere with administrative decisions. However, such interference should only be within narrow limits where there is a clear violation of statute or a constitutional provision or there is arbitrariness in the Wednesbury sense. It is the administrators and legislators who are entitled to frame policies and take administrative decisions as they think necessary in public interest. The court should not ordinarily interfere with policy decisions unless clearly illegal. Economic and fiscal regulatory measures are a field where the judges should encroach upon very warily, as the judges are not experts in these matters. The impugned policy parameters were fixed by experts in the central government, and it is not ordinarily open to this court to sit in appeal over the decisions of these experts. We have not been shown any violation of law in the impugned notification or press note. The power to lay policy by its executive decision or by legislation includes power to withdraw the same, unless it is by malafide exercise of power, or the decision or action taken is abuse of power. The doctrine of legitimate expectation are not relevant. Kindly come to paragraph 46. Kindly come to paragraph 44.
Yes.
Where Chief Justice Neely says that I am not an accountant. I am not an accountant, electrical engineer, financer, banker, stockbroker, or system management analyst. It is the height of folly to expect the judges intelligently to review 5,000 pages record addressing intricacies of public utility operation. It is not the function of a judge to act as a super board or with the zeal or pedantic schoolmaster substituting its judgment for that of the administrator. In our view, well, this is very important, there should be judicial restraint in fiscal and economic regulatory measures. The state should not be hampered by the code in such measures unless they are clearly illegal or unconstitutional. All administrative decisions in the economic and social spheres are essentially ad hoc and experimental. Since economic matters are extremely complicated, this inevitably entails special treatment for distinct social phenomena. The state must therefore be left with wide latitude in devising ways and means of imposing fiscal regulatory measures, and the court should not, unless compelled by the statute or constitution, encroach into this field. In our opinion, it will make no difference whether the policy has been framed by the legislature or the executive. The distinction is taken out. And in either case, there should be judicial restraint. The court can invalidate an executive policy only when it is clearly violative of some provision of a statute or constitution or is shockingly arbitrary, but not otherwise. The last one in this set of judgments would be 2020 18 SCC 527. But this was a case, my lord, where the had the occasion to consider whether the categorization of Hajj group operators on the parameters of experience and financial strength of AGOs, those Hajj group operators. Kindly come straight away to para 18.
Yes.
Going by the aforesaid considerations, the respondent has carved out the categories of AGOs, that is Hajj group operators, on the parameters of experience as well as financial strength of AGOs. Such a decision is based on policy consideration. It cannot be said that this decision is manifestly arbitrary or unreasonable. It is settled law that policy decisions of the executive are best left to it, and court cannot be propelled into the uncharted ocean of government policy. Public authorities must have liberty and freedom in framing the policies. It is well accepted principle that in complex social, economic, and commercial matters, the decisions have to be taken by the governmental authorities keeping in view several factors, and it is not possible for the courts to consider competing claims and to conclude which way the balance tilts. The courts are ill-equipped to substitute their decisions. It is not within the realm of courts to go into the issue as to whether there could have been a better policy, and on the parameters direct the executive to formulate, change or vary or modify the policy which appears better to the court. But such an exercise is impermissible in policy matters. Bennett Coleman referred to. Then the scope of judicial review is very limited. That is where paragraph 19 says so. Then at paragraph 20, my lord, the state of MP versus Nandlal Jaiswal. That is that liquor case. Now, my lord, now when I come to the next point, my lord, in this case, it cannot be said that the policy is discriminatory, as this policy is applicable to all the bidders. We have about 135 MSMEs, as we have stated in our affidavit. My lord, it is a matter of fact, subject to correction by Mr. Bagh, obviously will submit on instruction, that none, apart from the petitioner, none of the MSME has registered any objection against this policy or framing of this policy. Sorry, it has 137 MSMEs. Your lordship will find this at point D of my submissions. Now, coming to the petitioner. Admittedly, my lord, the petitioner.
But if okay, it cannot be considered. Suppose there are litigations and you have rejected, and subsequently against you only.
Yes.
And subsequently the petitioner on this got the fruitful result in his favor.
Absolutely, my lord. If the adjudication results, suppose, my lord, the effect. Absolutely, my lord. My lord, when a particular tender is floated, my lord, the employer, subject to lordship's kind consideration, my lord, in my humble understanding, would be entitled to assess the situation as on the date when the last date of the submission of tender. My lord, it may so happen it may so happen with my lord, my learned friend's client also, the petitioner, that they succeed in each and every litigation, or they succeed in some of the litigations. Then, my lord, obviously, when my lord, these tenders are, my lord, issued from time to time. My lord, these are ongoing processes, implementation of infrastructure projects which go on and on. So, my lord, subsequently, if it is found that yes, we have failed, it is our fault, then obviously for the tenders, forthcoming tenders, or the tenders which might be issued or are in process when the success comes in their favor, they have to be considered. But my lord, as on the date, there may be 20 litigations.
So that's why, see, why you are debarring, why you have taken the policy
But I am not
decision?
debarring, ma'am.
Why you have taken the policy decision? Because of the litigation pending.
Yes.
Correct.
Yes.
And the litigation ended in favor of the contractor.
Right.
So the contractor suffered the damages. What would be effect? You are right on that day.
Yes.
But on that day there is a litigation. He has not been allowed. But that litigation is succeeds.
Yes.
Who will be liable to pay the compensation?
I tell you, Lord.
And second thing,
Yes.
this is one, and second is,
Yes.
there might be in your office, you don't know, you have long, heavy business.
Yes.
You have the managing committee.
Yes.
The persons have some grievance against the petitioner
Right.
or some bidder. He know, yes, next month to bidder, the tender will be floated. File 1, 2 or cases against the petitioner.
My lord, I tell
Then
you,
what will happen?
My lord, I tell you, Lordship, my lord, may I take the example of the petitioner?
I am taking the negative way.
My lord, I understand. My lord, I have to answer. If I am unable to satisfy your Lordship, obviously, my lord, my client doesn't stand to gain. So, my lord, may I just answer to your Lordship's first query? First question is that, suppose they succeed, or any, my lord, forget about
That's why the bidder.
Forget about any bidder succeeds in the litigation, but in the meantime, he has missed out the opportunity to emerge as successful bidders. It's not that he's missed out the opportunity to participate in the bids. He has missed out the opportunity to emerge as successful bidders at the end of, my lord, the bidding process. My lord, in that event, my lord, the only remedy, that is my understanding, my lord, the only remedy is that, my lord, they will have to sue us for damages. They have to sue us for damages. The second issue is that, suppose, my lord, my lord, one of my employees has a personal grudge against, my lord, one of the bidder. It may so happen, my lord, with your Lordship's vast experience and with a little bit of my experience, we know what happens sometimes. So, my lord, the Lordship has extreme vast experience representing several activities. Your Lordship knows. That is why these questions are coming. So, my lord, in that way, my answer would be very simple, my lord. Suppose when the bid is evaluated, it is not evaluated by, my lord, the minions in the industry. The bid is evaluated by an expert committee. My lord, if any bidder says that the expert committee may also be influenced, then, my lord, every tender would be subject to, my lord, judicial review on account of, my lord, suspicion. But, my lord, because evaluation committee, my lord, is a body of expert. Then, my lord, may I take your Lordship to the case of the petitioner?
Because why I am telling, sorry.
Yes, I understand. Yes.
Because why I am telling.
More and more your Lordship ask me question better from me.
Why I am telling, in the administrative, in the service jurisprudence.
Right.
In the service jurisprudence, if a person is having a criminal incident or disciplinary proceedings, that's why to give the protection to the employee for the future promotion, the seal cover proceedings has been
Janki Raman.
Seal cover proceedings has been given. So
yes. But, my lord, the promotion is not given at that stage.
That's why the promotion is not given. Seal cover, then retrospective effect.
Yes, my lord, but your Lordship is absolutely on the point. There is one distinction which I may mark out. When we go through the law laid down by the Supreme Court in Ramanna Shetty's case, paragraph 12, if I correctly remember, my lord, Ramanna Shetty not only considers contracts but also jobs. The word used is also jobs. My lord, when sealed cover procedure at the stage of DPC consideration, that would come when the employee is already in service. But in this case, it is at the stage, at the threshold.
That's what I'm telling. That's
at the threshold. So,
That's
matlab,
what-
at the threshold, the option would be at that stage, matlab, that amount of free play in joints, matlab, the employee is entitled to.
Then again, I have to put one question.
Yes,
Then
please.
if pre that, if a person intend to enter into the service and having the criminal antecedent, he
Right.
has to give in the verification form pendency, and he will be given the 2 years of probation period for.
Right.
So what?
Malad, may I just indicate, malad, criminal antecedent, malad, there is a judgment rendered. Malad, I'm not relying on the judgment because I find that is not relevant. Because
No, that I'm
but,
telling.
no, in criminal
You
antecedent
have
is
given the suggestion.
malad, that is why malad, Delhi High Court had the occasion to consider a case where malad, bids are being rejected on the ground of criminal antecedents. Division bench, na? Malad, really, a division bench of Delhi High Court is of the view, subject obviously, malad, that is only of persuasive value for your lordships. Delhi High Court has held that that condition is valid. So far as criminal antecedents are concerned, your lordship will find your lordship has dealt with now many Bengal excise matters, right? Because lordship is in this determination. In Bengal excise, I will give your lordship an illustration. There is, malad, any attempt to disentitle a particular licensee or any participation and any application for license cannot be rejected merely on the ground that criminal case is pending.
Correct.
There is a circular or notification issued by that is pre-constitutional circular that he has to be the criminal case has to result in conviction, only in conviction. But criminal antecedents, in my most respectful submission before lordship, there is a distinction. Criminal antecedents, if they relate to execution of works by a bidder with respect to some other employment.
That I am not on. Only you have answered
yes,
to my question.
yes.
That I'm putting.
Your lordship will find in so far as criminal antecedents are concerned, even the application of service rules vary from state to state.
State to state and the department.
Sometimes the state rejects straight away. Sometimes the state, as you felt from my lord, that the employee is kept on probation and the confirmation is subject to the conclusion of criminal proceedings. That is but in some states, it may so happen that the criminal case, pendency of criminal case itself is bad enough.
With regard to that is in the force,
In
like a police,
right,
like a defense.
Right, it's the nature of the service. Nature of the service.
That's the nature of the service.
But this is very good. So whatever happens in the matter, this is a good interaction. So, may I proceed further, subject to lordship's kind consideration? But after a long time, Janki Raman came back to me. Nowadays, I don't do service matters. They don't come.
That's I also remember because
Janki Raman was a landmark judgment of 1991 or 92.
5-6 years has gone dealing with that.
Yes. At least now I understand the group 6 would be benefited. Your lordship take that determination. At least the petitioners would be benefited. So, may I take your lordship back to my note? Coming back to the case of the petitioner, my lord, now, admittedly, my lord, the petitioner has a long history of litigation. My lord, which would be against, my lord, against power utilities like, it's not about me only. Ajmer Vidyut Vitran Nigam Limited, Jodhpur Vidyut Vitran Limited, Punjab State Power Corporation, Purvanchal Vidyut Vitran Limited, Jharkhand Bijli Vitran Limited. We are given an entire chart at pages 63 to 65. They have not denied. That's there.
Naturally.
And identical provisions regarding declaration of litigation history have been introduced by different power utilities. We have given the table at page 48 of the AO.
Okay.
Their case is that once it is illegal. Now, I attempt to analyze the submissions made on behalf of the petitioner. First submission was like this, that the office orders clearly violate sections 10, 23 and 28 of the Contract Act. Now, in the present petition, the petitioner has not challenged the office orders, on the grounds of violations of Indian Contract Act 1872. But this is where Rule 11 of our REIT rules come into play. Well, kindly take Rule 11 for once. কোনটা? না ওটা দরকার নেই। Kindly take Rule 11. Your Lordship will find that, my lord, practically a writ petition can be moved only on the grounds pleaded therein.
Yes.
So, my lord, if it is not there in the grounds, either they have to amend the pleadings, my lord, I do not stand in the way, or, my lord, they have to abandon this plea.
Later judgment of the Supreme Court.
Yes. they,
Before yesterday.
they can amend, they can definitely amend, but that is not done. Now, my lord, I am not referring to the judgment. This is 2020 SEC Online Calcutta. But, my lord, in any event of whatsoever, let us forget about everything. Tender is not an offer. The problem that the tender is an attempt to ascertain whether an offer can be obtained with margin. Kindly take 2004 8 SCC 671 para 12. এই আমাকে একবার কোথায় দিয়ে দিলে তুমি para 12 আমি দিয়ে দিচ্ছি। Kindly take placitum E at para 12.
Yes.
An invitation to tender is not an offer.
Para 12.
Para 12, placitum E.
Yes.
An invitation, my lords have got that. An invitation to tender is not an offer. It is an attempt to ascertain whether an offer can be obtained with a margin. My lord, my case before lordship is very short and simple. My lord, the provisions contained in section 10, 23 and 28 of the Contract Act cannot be placed into service before formation of the contract itself. Their contract is yet to be formed. The lordship will find the 23 cases. Well, now we are talking about service matters, it's very interesting. Take, my lord, Deshbandhu Ghosh, take Brojonath Ganguly, take DTC versus DTC Mazdoor Union, all, my lord, employments of contracts of employment entering. Now, my lord, during the course of hearing of the writ petition, the petitioner relied on the following judgments, which are not applicable to the facts of the present case. Well, I have given the reason for why. In Vinishma Technologies 2025 SCC Online, SC 2119, well, in the impugned tender condition in that case before the Supreme Court, provided that the bidders must have supplied sports goods worth, this is at paragraph 7, sports goods worth at least 6 crores cumulative to state government agencies of Chhattisgarh. So it was restricted to the bidders of Chhattisgarh. So it was basically the competition was limited to
restricted some area
territories. So that condition, the Supreme Court held that the object of public procurement, your lordship will find that at paragraph 19. Kindly take paragraph 19 for once.
The judgment kata hai,
Mallory has got a copy of the judgment.
Judgment. Judgment diya. Yes.
Well, the object, Mallory, if your lordship, kindly takes paragraph 19.
Yes.
The object of public procurement is to secure quality goods and services for the benefit of public exchequer. The said object can be achieved requiring the bidders to demonstrate financial capacity, technical experience, and past performance in contracts of similar nature, regardless of place of performance of the contract. To confine the eligibility to participate in the tender within one state is not only irrational, but is also disproportionate to the goal of ensuring effective delivery of sports kits. So, my lord, I would beseech your lordship, my lord, I'm intending to supply much emphasis to the first sentence of this paragraph. The object of public procurement is to secure quality goods and services for the benefit of public exchequer. But for the when the expression or phrase for the benefit of public exchequer has been consciously used or employed by the Honorable Supreme Court, well, it would mean, subject to my understanding, that one has to, the employer has to, or the tender evaluation committee has to bear in mind whether any award of contract to any bidder may have the risk of increasing the litigation costs, having regard to the litigation history of the bidder. So, my lord, this principle does not militate against the submissions which I am trying to buttress before your lordship. Now, the next judgment, my lord, is Eurasian. That's, my lord, kind of locus classicus. Kindly takes Eurasian judgment, Eurasian equipment and chemicals versus State of West Bengal, 75 1 SC 70. That was a case of blacklisting.
Yes.
Blacklisting would mean, my lord, not only the bidder or the contractor would be prevented from participating in the bids floated by the employer issuing the blacklisting order, but also in other bids also. Kind of, because they have to give a declaration whether any blacklisting is pending against me. The last judgment, subject to correction by Mr.
Kimberley.
Bach, is Kimberley. And that is some condition which was not even provided in the NIT has been sought to be invoked for the purpose. But that is not the case. This is an office order where the conditions are challenged. But my conclusions, would your lordship rise, my lord?
No.
Yeah, I'm at the end. I'm nearing the conclusion. Well, it has been held by in Tata Cellular that the state within the meaning of Article 12 of Constitution must have freedom of contract. In other words, a fair play in the joints is a necessary concomitant for an administrative body functioning in an administrative or quasi-administrative sphere. This is paragraph 94, the summary. Clause 14.00 and the undertaking in Form 11 can neither be termed as arbitrary nor unreasonable, so as to offend Article 14 and 19(1)(g) of the Constitution of India. It is again my respectful submission before lordship, subject to lordship's kind consideration. The respondent is well within his right to introduce such a provision while taking a decision as to whether it would be commercially expedient to enter into a contract with a party which is a habitual litigant. At the stage of tender, which is merely an invitation to offer, the provisions contained in 10, 23 and 28 of Contract Act cannot be placed into service. The likelihood of increase in litigation cost is a factor which the respondent has to consider at the time of awarding contracts. So these are my respectful submissions. So grateful to your lordship.
Thank you.
Yes, I'll take 5 minutes, my lord, and I'll conclude. I'll not repeat, my lord, the submissions which I have made on merits. First point which has been, my lord, indicated, Rule 11 of the writ rule, because it is contended that we do not have any grounds where we have taken these points. Lordship will kindly make a note of the grounds where these are mentioned, and I'll indicate those grounds very quickly. Because in the petition, it's the material facts. In the grounds, with the material facts, a hint. It's a point of law. But where is that hint taken is ground numbers 9, 10, 11,
Ground
12,
9,
9, my lord. 9, 10, 11, 12, 13, 16, 17, 23 to 25, and 28.
Yes.
I'll quickly indicate, my lord. Ground number 9 is where we have stated Nine, my lord, that second line, my lord, seeking to restrain the petitioner from instituting this, which MSME Act, my lord, kindly mark this, MSME Act expressly gives the right. We have stated that. Now, my lord, ground number 10, the last line. We have enumerated articles 14, 19(1)(g), 21. Next, my lord, ground number 11. The second last line and the last line. Repugnant to the laws of the land as enacted and captured in also the MSME Act. We have stated, my lord. Now, ground numbers 12 over the page, my lord. Third line. Shall have an overriding effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Ground number 14, third line, my lord, to be struck down as they have deliberately issued to prevent the petitioner from participating. Your lordship will then kindly take up, I'm sorry, ground number 14 was not there, 13, 16 and 17. 16, my lord, the last line again, at page 24, my lord. 16,
yes,
article 14. Then 17, my lord, we have stated fourth last line, ultraviolence the constitution amounts to manifest arbitrariness in exercise of discretionary power, cannot be so exercised, article 14 again. This is ground number, my lord, 24. Then, my lord, over the page 25 and my lord 28. I'm sorry, 28.
Ground 28.
25, kindly take up once, my lord. 25, we say, second line, are contrary to the statute. It's at page 26, my lord. Contrary to the statute.
Yes.
And then, my lord, page 27 is ground number 28, otherwise bad in law. So, set the premise, my lord. Can't be said that rule 11 will apply because we have not kept the grounds. Grounds are there. Now, quickly, my lord, I'll show, before I make one submission, my lord, a list has been given in the notes, page 3, as to who we have filed litigation against. We do not dispute that. There's no way, my lord, we can be stopped from filing cases challenging, my lord, the illegalities perpetrated by any entity. So that list would not affect the merits of this matter in any manner. My lord, in page 4 of the notes, para F, identical provisions.
Page?
My lord, page 4 of the notes, paragraph F, my lord.
Yes.
Identical provisions. I pause here for a moment. Lot of murders go undetected, hence this should not be detected. That can't be the reasoning. That can't be the reasoning, my lord. That's all I have to submit on this. Kindly take up, my lord, the judgments, and I'll show how these 4 judgments, which have been relied upon by my learned senior, my lord, 4 judgments, I'll indicate each of these judgments I'll distinguish them, and they are to our benefit, and I'll indicate that. Can you take up the first judgment, Manohar Lal Sharma? Paragraph 14 was, my lord, relied upon. The second line, I'll quickly read these 2 lines, my lord, and show how this is in our favor. On matters affecting policy, and I pause here for a moment. This is not a policy decision. But it is not a decision where, my lord, Article 50 comes in play. That we cannot, my lord, that segregation, and I'll indicate, my lord, on matters affecting policy, this code does not interfere unless, kindly mark this, my lord, unless the policy is unconstitutional, that's our case, it is unconstitutional, or contrary to the statutory provisions. We have shown that. This is contrary to statutory provisions, or arbitrary, or irrational, or in abuse of power. All parameters, my lord, are covered in our case. Hence, these exceptions are where, my lord, we fall. Hence, the invitation to interfere, and my lord, set this aside. That's the first judgment. The second judgment, my lord, is Bhagyanagar Energy versus BSNL. Paragraphs 10 to 12 was referred to. Lordship will kindly take up paragraph 12.
Yes.
But in the middle of the paragraph, it shall not interfere with the policy. It shall not interfere with the policy decision unless, my lord, kindly mark this part, unless it is demonstrated and shown that the policy decision taken is capricious or arbitrary, or is not informed by any reason, or it suffers from the vice of discrimination or infringes any provisions of the statute or of the constitution. Our case, my lord, falls within this parameter. And also, my lord, I should indicate, last line, my lord, does not affect the economy of the country. This is not, my lord, on an economic, my lord, policy. It is not. It's not affecting the economics of the country. The next judgment is Bajaj Hindustan, my lord. Paragraphs 38 to 45 was referred to, and 46. Your lordship will kindly take up paragraph 45.
Yes.
In our opinion, there should be there should be judicial restraint in fiscal and economic regulatory measures. This is not so, my lord. The state should not be hampered by the court in such measures. Now kindly mark this, my lord, unless they are clearly illegal or unconstitutional, which is our case, my lord. We say it is illegal and unconstitutional. All administrative decisions in the economic and social sphere. This is not an administrative decision either on the economic or on the social sphere, my lord. Hence the distinction here. And the last judgment, my lord, is Federation Hajj PTOs of India. Paragraphs 18 to 20 was relied upon. I will, my lord, indicate that one paragraph because my learned senior friend said paragraphs 18 to 20. He read out 18 and 20. 19 he did not. My lord, 19 I'll quickly read out. Before that, my lord, paragraph 18, the third line, my lord. I'm very grateful, my lord. Such a decision is based on policy considerations. None here, my lord. It cannot be said that this decision is manifest. So that decision in that particular matter, not connected in any way over the page.
That's why it's called each cases is having its own
Indeed,
facts.
indeed, my lord. Unless the ratio is absolutely, my lord, applicable. Over the page, my lord, uncharted ocean of government policy. That's why, my lord, I submitted Article 50. This is not one of those cases, my lord. Public authorities must have liberty and freedom in framing policies. It is well accepted principle that in, kindly mark this, my lord, complex social, economic and commercial matters. This is not a complex matter. Is neither falling in any of these parameters. Decisions have to be taken by a governmental authority, keeping in view several factors, and it is not possible for the courts to consider competing claims and to conclude which way the balance tilts. Courts are ill-equipped to substitute their decisions. It is not within the realm of the courts to go into the issue as to whether there could have been a better policy, and on that parameters direct the executive to formulate. That's very important, my lord, because this is not one of those cases where we are inviting the honorable court to do this. Now the paragraph which has been left out, paragraph 19. The scope of judicial review is very limited in such matters. Kindly mark this next line, my lord. It is only when a particular policy decision is found to be against a statute, but kindly mark this, or it offends any of the provisions of the Constitution, or it is manifestly arbitrary, capricious, malefic, the court would interfere with such policy decisions, and there, my lord, no such case is made out. Here, that is made out.
Yes.
These are my respectful submissions, my lord.
Thank
Well,
you.
one quick response. My lord, my learned friends relies on certain grounds which are relatable to MSME Act. The notes submitted by my learned friends
Also
are
the law, I've said that.
no, MSME Act. There is nothing to suggest in the notes. It's as submitted on behalf of the petitioner that the petitioner is relying on the ground that the policy is violative or the office orders are violative of MSME Act. Kindly take the notes so submitted by.
Lord, we have also stated laws in force in the country, which means the contract law. Definitely.
Laws in force as such. The language is as such in the grounds.
My lord, one more judgment, which, my lord, I'll not.
But I think, my lord, my learned friend is not relying on the provisions of MSME Act.
My lord, one judgment, my lord, Anil Kumar Srivastav, my learned senior friend, has relied on this, paragraph 12. Invitation, either way, my lord. If it's an invitation to offer, I'm not even going there because, my lord, even if it's an invitation to offer, if the clause restricts us in a manner, my lord, that affects our statutory rights and the fundamental rights, then, my lord, the petition is, my lord, to be maintained, and this prayer that we have made, my lord, is to be.
But I'm given to understand that he's not relying on MSME Act.
I've made my submission.
No, my lord, the notes are very important.
Yes.
Otherwise, I will be ambushed, my lord.
Thank you.
I'm very deeply grateful.
Thank you. Thank you.
May I take
Hearing
back
concluded, CAV. No, take I. And you have put the note, then I will see.
Yes, yes. So great.
Deep privilege.
Yeah. Both are similar.
Both are similar.
Both.
Both are similar.
Second one will cover the first occasion, the second matter.
Okay.
Second matter
And
will
the
cover
first will not be.
Not a real, not relevant.
Yes.
Yes.
Deep privilege.
अभी अनलाइज करेंगे ऑडिटर का
12 बजे है क्या?
These are bulk matters, my lord, your lordship remembers.
122. Yes.
Lord, all the time, my lord, your lordship has been gracious enough to allow me to go to different places, my lord. On lighter notes, on heavier notes.
Now this time you take Mr. Tiwari.
I will.
Only because you are not taken Mr. Chatterjee, but you take Mr. Tiwari.
Last occasion, your lordship directed us to file a report. But this is the
Copy? But they didn't serve us anything earlier.
this is the internal communication between the two departments.
No, but there was supposed to be something more concrete which was supposed to be given to us.
अनलाइज करेंगे ऑडिटर का हाँ আমার ভিড়টা কোথায় করতে পারছি আমার ভিড়টা কোথায় করতে না না that's not the point আমার তো কোনো মার্কস ছিল of old
Correct. ওই কাগজটা if you want to that is there. Correct.
Yes. Let
I wouldn't know what they
give what is that? Nothing.
My lord, the whole story, first of all, my lord, on an earlier occasion, your lordship had indicated that we should give a written notes of submission. My lord, this is the written notes of submission. But before your lordship sees that, what is it that we are battling today? We are battling today an LOC or LOCs which were possibly opened in around 2023, which have not been renewed. That's the first limb of submission. If what is the principle governing LOC, my lord, your lordship would have a look. This is what the internal circulars mandate. They have it as their internal document, which is available on the website. Now, I would beseech your lordship to see three things. Kindly see page 1, point number 6.
Yes.
Validity ordinarily 1 year. Right, my lord. Now, the next word is subject to review.
Correct.
Right. Now, my lord's pleasure would be to kindly come to the next page.
Again, number 6. On top, your lordship would see subject is consolidated guidelines regarding issuance of LOCs. Right? In that, number 6 is validity for 1 year, subject to review, unless otherwise specified, and shall be reviewed periodically by the originating agency. Right?
Who has issued that? Yes.
Who has issued it? Now, over here, my lord's pleasure would be to kindly come to page 3. Now, this is also an internal note. In this internal note, which is available on the website, my lord, this is what which is coming up since 2010, if your lordship sees the date on the top. Now, over here also, sees point number 2. Further, majority of the originators do not review their LOCs within the stipulated validity period of 1 year. In view of the above, it is requested that the following guidelines for opening of the LOCs may be circulated to all concerned under your jurisdiction for strict compliance. Now, kindly go to page number 4, IV. The internal document. The internal document. Oh, this is given. This is given.
Give copy. Journally available. Then I have to check again and come back.
If they could hold on to their master circular, not giving it to us, well,
No.
I'm relying on something.
Not that.
Yes.
They don't know how many circulars are there. Unless and until you identify the exact circular, then only.
What my Leonard senior friend will be relying today, because he is handing over a written notes of
Page 4.
which is even thicker than the petition. We are not aware what is there in there.
Everything is given. It's given.
Affidavit of service.
Yes, given. Now, kindly comes to page 4, IV. Now, again, it is the responsibility of the originator to review the LOC before the expiry of the validity period of 1 year. And also to provide additional identifying particulars of the subject. Now, my lord, with greatest respect, this would be pertaining to the list which has led the originator to issue. It can't be abstract.
Yes.
Or it cannot be a situation where on a subsequent action, an LOC is permitted to continue indefinitely. This is the rationale or the reason d'etre behind page 4 internal IV. And that is the reason why it gets formulated into guidelines which I've shown your lordship in page 1 and 2. Now, my lord, to bolster my argument, your lordship would kindly see page 5. This is the pro forma.
Yes.
In the pro forma, this is how it is supposed to be. This is also available. This is how it is supposed to be. Now, my lord's pleasure would be to kindly come to page 6. In page 6, sees on the top.
Reason
This is the necessity of. Kindly sees this is the necessity of reason for opening criminal case, specify full details.
Where from you are reading?
Well, page 6, IV again. Page 6, IV on the top.
Yes.
On the top. Kindly note criminal case, specify full details.
Correct.
Then you have FIR date, section of law when applicable, police station, district, country, wanted by law court, judicial authority, name of the court, order. Name of the authority authorizing the LOC. Specific period of retention of LOC months. Now, retention of LOC cannot exceed 12 months or 1 year in terms of MHA order number so and so dated 2000. Right? Requests for renewal are to be made by competent authority from time to time or on yearly basis. Because what could have necessitated on the first year might not be the necessity of next year.
Correct.
But keeping this principle, my lord, just keeps this principle in mind. Please have the order of the Delhi High Court. Just on this principle. But your lordship was aware of this order that we've shown. It is in your lordship's file, Anand Raj Kanoria.
You can give another copy,
Yes, it is there. Yes, because your lordship was marking it. Keeping this principle in mind, now my lord's pleasure would be to kindly take up few paragraphs of this. This is pertaining to the same list a different accused has approached the Delhi High Court. On the same list, my lord.
kindly comes to page, paragraph number 1. The present petition has been preferred under Article 226, seeking quashing of a lookout circular against the petitioner for sake of so and so. It is quoted. Now, my lord, kindly comes to paragraph number 2.
FIR number.
Yes. Now, what is German, my lord? I'm sorry, my lord. Before your lordship sees paragraph number 2, sees on top paragraph the prayers in IV, V, and VI. I will not read it. Your lordship would have a look at it. While your lordship is reading VIV, it is the same LOC which is in question.
Yes.
Now, my lord, sees VII and sees the second line of the prayer. Pass any order, my lord, a very general prayer, but how this becomes relevant, my lord, I'll show your lordship. Pass any order or for such further orders as this honorable court made him fit and proper in the facts and circumstances. My lord would kindly note this. This has direct bearing because the facts and circumstances have been taken into consideration. Now, kindly comes to paragraph number 2. The facts of the case would manifest. In the year 2010, the petitioner was diagnosed. My lord, this particular line is inapplicable because I have gone abroad. 5 people before your lordship, they've gone abroad for different reasons. But the reasons were, it's stated in the writ petitions. He claims to have undergone treatment. Some of us have also done the same. Kindly see the next. After undergoing treatment, he came to know one FIR. This is, my lord, extremely pertinent. Bearing number so-and-so is the same FIR was registered with PS Kotwali, Jaunpur, Uttar Pradesh on the basis of materials in the said FIR on so-and-so and ECIR being number so-and-so was registered. The petitioner claims to be residing in Delhi and presently operating a startup company named so-and-so. He stated so-and-so enforcement directorate. These are common in Kolkata and Delhi. And when he was scheduled to fly, this malad restrained in Indira Gandhi so-and-so, and he was informed about the existence of LOC. Pursuant to the search, a show cause notice was issued. Now, kindly see paragraph number 5. The petitioner contends that he is neither an accused in the FIR nor named in the ECIR. Stop here for a moment. I am named in the FIR. Please keep this in mind. Some of us are named in the FIR, some of us are not. But the principle governing the law will be the same. An accused in the FIR, none in the ECIR, though his close relatives have been erased. I am the relative. It is contended no FIR ECIR is pending against the petitioner. Rather, an ECIR is registered against his family members remains under investigation. According to the petitioner, the FIR number so-and-so on the basis of which the ECIR was registered, kindly note this line, Manad, has already been closed. This is common. If your lordship sees the top line, FIR is against, he says, I'm not named in the FIR. Relatives are named in the FIR. This FIR has remained closed. So factually, everybody is closed. One was not named, 4 are named. But since it's closed, the effect is the same thing. Has remained closed.
You are the named person.
I'm the named person, but it is closed.
Correct.
It is closed.
Correct.
Right. So eventually, the law mandates what is existing as on today would have to be seen. This is non-existent, which is appearing from the Delhi High Court's order. And since the ECIR is founded solely on the materials collected therein, its continuation in view of the settled legal position cannot be sustained. Mr. So-and-so, learned counsel for the so-and-so flagrant violations of office memorandum dated so-and-so and the binding decision of this court as well as of Supreme Court. It is contended that the law is well settled that once the predicate offence stands quashed, the accused persons are deemed to be discharged from all consequential proceedings. He further submits that the petitioner shall undertake to fully cooperate with the investigating agency as and when required. But the investigating agency is ED. They are over here, on board. On notice being issued to various objections, the Enforcement Directorate has pointed out that that earlier an FIR was lodged against so-and-so, 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 and the Kanodia family members. But these family members are before your lordship. It is also submitted that a new FIR, which my learned friend was trying to indicate, is also mentioned over here, Balat. It is also submitted that a new FIR being number so-and-so, dated so-and-so, has been lodged with Electronic Complex Bidhannagar Police Commissionerate under section so-and-so against the directors of so-and-so. And so-and-so
for that an incident of fraud amounting to rupees about 100 crore, about 1,000 crores
91.
has occurred. UCO Bank, flagship are located at so and so. Now, Mr. So and so learned counseling appearing on behalf of ED submits that the ECIR earlier registered is required to be examined in the light of the allegations that have subsequently surfaced in FIR number so and so. This is the present one they're talking about. It is further submitted that an SLP challenging the closure report in FIR number so and so is presently pending before the Supreme Court. Matlab, this is the Jaunpur FIR which is stood closed, wherein a separate application seeking a stay has also been filed. However, as on the date, no orders have been passed thereon. It's the same condition today also. Mr. So and so further contends that the role of the petitioner is being examined and that the allegations are that the petitioner was responsible for opening and operating multiple accounts abroad and was a signatory thereto. So this fact is also brought to the notice that the current FIR, where investigation is continuing, they are getting materials implicating the petitioner therein before the Delhi High Court. Now, therefore, according to Mr. So and so, the matter may have wider ramifications. I've heard the counsels. My lord, now kindly see paragraph number 10. At the outset, it is pertinent to note that the evolution of guidelines governing the LOC, the earliest instruction emanated from a letter issued by Ministry of Home Affairs dated so and so, which authorized various agencies to monitor the arrival and departure of Indian citizens as well as foreigners. Thereafter, a more structured framework confined to Indian citizens was introduced by Office Memorandum dated so and so. Then Supreme Court judgments are quoted. Now kindly comes to, in fact, in this only, my lord, paragraph number 11 subsequently leaves the first 3 lines. Subsequently, the Ministry of Home Affairs issued a comprehensive office memorandum dated, the one which is before your lordship, which confined the issuance of LOC to cases involving cognizable offences under so and so, and restricted non-cognizable offences to intimation of travel movements only. Subsequently, amendments, including office memorandum dated so and so, further limited the scope of LOC in exceptional circumstances wherein the departure of a person was considered prejudicial to the sovereignty, security, integrity of India, bilateral relations, strategic or economic interest, or larger public interest, with further modifications effected in memorandum dated so and so and so and so. In order to consolidate the directions of the issuance of LOCs, the Ministry of Home Affairs issued a comprehensive office memorandum dated so and so, which presently governs the law which respects issuance of LOC. With respect to issuance of LOC, the relevant extracts of the office memorandum is under. Number 6, the existing guidelines with regards to issuance of lookout circular in respect to Indian citizens so and so have been reviewed by this ministry after due deliberation in consultation with various stakeholders and supersession and suppression of all existing guidelines issued by the Ministry of so and so referred to in para 1 above. It has been decided that the approval of competent authority that the following consolidated guidelines shall be followed henceforth by all concerned for the purpose of issuance of LOC in respect of Indian so and so. Now, my lord, this is what is stated. 1 and 2. 1 is cognizable, non-cognizable. H and I. Sorry, not 1 and 2 is H and I.
H and I.
H and I.
They are cognizable and non-cognizable.
Cognizable, non-cognizable. Now, kindly sees L. In exceptional cases, LOCs can be issued even in such cases as may not be covered by the guidelines above, where departure of a person from India may be declined at the request of any authorities mentioned in B, if it appears to such authority based on inputs received from the departure so and so, that the same is detrimental to bilateral relations with any country, the strategic economic interest of India, or such persons is allowed to leave, he may potentially indulge in an act of terrorism or offense against the state, and or such departure ought to be permitted in the larger, ought not to be permitted in the larger public interest at any given point of time. Now, Supreme Court is quoted. Now, kindly see page 14, the last line, held that power to issue LOC is an exceptional and coercive measure, which is directly bearing with the individual's fundamental right to travel and therefore must be exercised strictly in accordance with law. Now, Supreme Court again In Sandeep Dhanuka, my lord, everything is quoted, so it helps us. I don't have to cite separately. My lord, it reviews everything and it states.
Yes.
It continues and it continues and continues the whole thing, my lord. Now, my lord, kindly comes to paragraph number 16. Just before paragraph number 16, your lordship will see that there's a paragraph number 20. Para 16, bold para 16.
Yes.
Just above that, your lordship would see a quoted para 20. In that, there's a line which is underlined, which is the Delhi High Court. In fact, the Supreme Court has indicated. LOCs are being issued at the instance of investigating agencies where apprehension is raised by investigating agencies that the persons who is alleged to have committed an offense might escape the clutches of law by leaving the country. However, the law is also getting crystallized that merely because there are some revenue implications, the LOCs cannot be opened against a person. This also finds favor with the Delhi High Court because it finds favor with the Supreme Court. Now it comes to Rajesh Kumar Mehta, where again LOCs are quoted. Now comes to the next page, paragraph number 26, it's highlighted. And this quotation, while Supreme Court is doing, my lord, it's drawing its inspiration from Maneka Gandhi. Your lordship will see paragraph number 26, quoted. Over here, lookout circular is a major impediment for a person who wants to travel abroad. There's plethora of judgments which says that no person can be deprived of his right to go abroad other than for very compelling reasons. And then Maneka Gandhi is quoted. Now Shalini Khanna is quoted in that, my lord, paragraph number 17. But there's a reason why everything is getting quoted. Your lordship sees paragraph number 21. It is highlighted again.
Yes.
Now over here, your lordship would see there is a principle called not as a matter of routine. Now over here, there are situations which is happening where some subsequent actions are being taken in order to justify a previous action. The subsequent action which is being attempted to be brought through
by way of second FIR.
By way of second FIR is one aspect. ED attempting to rely on second FIR, trying to stall is one aspect. SFIO triggering in right now in April is another aspect. So you have multiple agencies attempting to stall because for the last 6 years, nobody has come up with a conclusive statement with regards to my guilt. With one FIR, the primary predicate offense being closed, which is observed by Delhi High Court. Now, my lord kindly sees the rationale behind this particular order, which comes from paragraph number 20.
Yes. Yes, Mr. Tiwari, take seat.
No.
No chair.
No chair, sorry. Kindly sees 19 and 20. Kindly sees, sorry.
Yes.
Kindly sees 19 and 20. 19 becomes extremely relevant and germane. Turning to the facts of the present case, a cumulative assessment of the materials on record demonstrates that on the date, the petitioner is not named in the FIR. Malad stops here for a moment. Chart sheets, FRTs are filed, which the subject matter is pending in Supreme Court, where everybody has to discharged in the primary predicate offense. So everybody is standing on the same footing. Next line. Even with respect to alleged role attributed to the petitioner within the ambit of ECIR, the matter has remained at the stage of investigation only. Huh? No, this is
ECI. Okay. Yes, ECIR.
ECIR only. Now, ECIR is of the primary offense which is gone. So the Delhi High Court takes cognizance of that and says that even if you look at the fact that they are continuing investigation, the validity of the investigation is a subsequent issue. That issue has also been raised. But the Delhi High Court says that you have issued this from 2023. We are at 2025 when this judgment is being passed in 2026.
3.5 years have gone by. January, so 3 years then, for us it's 3.5 years. 3.5 years investigation is pending. Your first FIR predicate offense is gone. Second FIR has started because of someone else. You are trying to piggyback and be a parasite on that and trying to stop me, whereas you have not basically fructified your investigation by culminating into a complaint. So today, it's an open-ended investigation which is continuing for 3.5 years. And there is no list before the court.
With regard to the action.
With regards to that. Right, consider this, my lord. That is the reason why paragraph 19, the last line becomes of extreme importance. The matter has remained at the stage of investigation only.
Correct.
The only is because you have not fructified it. You've not filed a complaint and said that, look, in 1.5 years, we've managed to complete the investigation.
File a report, then
File a report. We're continuing with subsequently with more information, investigation. That is not the case. Now, the LOC in question appears to have been issued in the year 2023. Thereafter, the petitioner was summoned to join investigation on several locations, namely so-and-so, 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 but we were also summoned similarly. Significantly, no summons or communications have been issued to the petitioner by any investigation agency subsequent to this. Similar situation so far as I'm concerned. It is also pertinent to note, now Malad, this is where your lordship comes in. It is pertinent to note that during pendency of the writ petition, the petition has been permitted by this court as many as 7 occasions to travel abroad. And there is no allegation whatsoever of misuses of such liberty or non-cooperation by the investigation. The date of the order and the duration for travel allowed is extracted here and below. But this we've also quoted in our written notes of submission. We've indicated for whom and for how many times, Malad. Your Lordship has been gracious enough to allow me to go to Bangkok, Malad. We've been ever grateful for that. So this Malad,
and the very first day you asked for the bill.
And the best part was one more extra day. One more extra day. I remember your Lordship's magnanimity, so that was concerned. Then Mr. Vaniji, take one more extra day, more than you asked for.
Yes.
Now, paragraph number 22. Thus, as of now, it remains undisputed that the petitioner has been allowed to travel abroad as many as on 7 over here will be on multiple occasions passed by this court.
Yes.
In such circumstances, the continued restraint imposed upon the petitioner by way of the LOCs operates as an unwarranted restriction on his personal liberty and right to travel under Article 21 of the Constitution without any contemporaneous justification. The mechanical continuation, Malad would kindly note this word, the mechanical continuation of LOC, despite the absence of necessity of the petitioner for investigation at this stage, renders the restraint prima facie arbitrary, particularly when the petitioner has neither evaded the process of law nor shown any inclination to obstruct the investigation. This is identical to what I have. But at this stage, it is noteworthy that the court is unnecessarily burdened in passing interim orders in such matters. The time spent in adjudicating such lists could be better utilized in dealing with cases involving substantial rights and pressing issues of law and resolving such cases at the first instances which may lead to more efficient use of judicial time. It's a very, very good judgment. Under these circumstances, keeping in view of the principles laid down by this court in the aforementioned cases, the court quashes the impugned LOC with the following directions. Now, Malad, there are directions which can be issued on me also. Similar directions. One is petitioner submits to submit an undertaking on affidavit by before the ED affirming that he shall continue to cooperate with the investigation, if any, and shall appear before the investigating agency as and when required. He shall produce all materials, documents requested from him by the investigating agency as may be available within his powers and possession. But this becomes very important. The word power is given because it also precludes a situation of Article 20, Clause 3. Now, we have number 3. Henceforth, he shall furnish a full itinerary before the investigating agency 7 days before undertaking any journey abroad. Fourth is, in case investigating agency has any reservation about the petitioner's travel, the investigating agency shall be entitled to either restraining him or issue fresh LOC.
Not challenge this order.
This order is not challenged. Same list.
And my lord, we have the additional ground that we are taking along with this non-renewal of LOCs.
That we also.
I think, my lord, this particular judgment of Delhi High Court on this same issue, well, it is binding upon my learned friends. Other than, my lord, তোমার রেসপন্ডেন্ট নম্বর কত? না, রেসপন্ডেন্ট নম্বর কত? তোর এত এক্সাইটমেন্ট কেন? আমার কি তুমি রেসপন্ডেন্ট নম্বর কত? কোন পিটিশন? পাঁচটা পিটিশন আছে। But other than, my lord, my learned friend, where Mr. Tiwari, he is bringing in the concept of SFIO, which was not before this, which was not before the Delhi High Court. So this is something new which is created. Now, my lord, now let us, if my lord, your lordship would kindly take up this document for one, which they have given. With reference to your letter dated so and so on the subject matter, it is stated that the present SFIO investigating into the affairs of so and so is at an initial stage, prima facie perusal of information, RD inspection, so and so forensic transfer audit report has revealed the following issues. Funds were routed. Now he goes on the, my lord, facts, right, which have not stood trammeled before any court of law till now. So these are prima facie issues which are there before various courts. And, my lord, may I say, it is with respect to Mr. Bhattacharya, he is indicating it, my lord. Goes to the next page. It is noted that Hemant Kanoria was the promoter and chairman and managing director of Shree and so till supersession of his board. He was a signatory.
Yes.
Till so and so. On the other, Sunil Kanoria was a promoter, designated so and so. Therefore, both Hemant and Sunil are identified as individuals, key roles. So far as these two persons, are concerned, we'll submit separately on the next day, because we need to deliberate a little more on this by taking instructions. And so far as the others are concerned, there's nothing which remains. Delhi High Court order governs everything.
How many petitions? This is
Five.
This is 4575 is the Sunil.
Yes, এবার আমরা বলতে থাকো।
Sujit.
Yes, my lord. 4575 is এবার advocate record সামনে এসো।
This is the last order. This is the last
order
passed by your lordship.
1/7
It's a common order, all cost type.
2026.
So Sujit and Hemant, these two.
No, my lord, Sunil and Hemant.
Sunil or Hemant.
22767 and 22781.
Okay.
These two, my lord, we argue on the next day. So far as Sujit is concerned, 4575. Sorry.
Sujit, Hari, and Raghav.
Correct. They are completely going to be governed by my lord, Delhi High Court. And this is a subsequent issue, my lord. We need to take a little instructions on that. My lord, your lordship would kindly give us one more day whenever your lordship feels.
Yes.
I don't want to waste time on.
Keep it on. Let him finish first. Let him finish first.
When will come?
Next week. We want to keep the
In the
we
month of
want to-
August, keep it.
No, no,
Month of August, no. After independence,
your lordship is understanding what is going on.
let him go, after 15th.
In the meantime, he said the 15th August, he may be given free hand.
Yes.
Independent.
I am independent now. Yes. I'm very grateful to my learned friend. May I continue to remain independent? Your lordship would kindly give next week, my lord. Next week, any day. Any day.
Next week, I don't think of it. 12 बजे कौन सा film मिलेगा?
First week of August.
30? It is July. 30th July. Learned Counsel for the petitioner has concluded the argument in respect of WPA 474575/2025, comma WPA 20081 of 2024, comma WPA 4577 of 2025. As regard the hearing of the remaining two writ application, the comma, the petitioner prays for time to take instruction with respect of the report submitted by the SIFO dated 14 July 2026. The report submitted by Mr. Tiwari appearing, you are appearing for SIFO. be kept with the record. List the matter on 30th July at 12 noon. Grateful. You then.
Huh?
Now let they complete. Let they complete. You will want. Yes, yes, yes. Let they complete. Let they complete and Mr. Tiwari, if necessary, Tiwari will
correct,
start.
correct.
Then we'll
Right.
see to that. No
Right.
problem.
Grateful, my lord. Grateful.
Yes, next.
My application, my lord, I had concluded on the last day. My learned senior friend was to take instructions, my lord.
Yes.
They relate, my lord, to that tender where two of the plots, my lord, my learned friend could not
Yes, yes, yes.
hand over possession, my lord. But we have prepared a short list of dates, my lord. Quite a few facts are there, my lord, with the respective page numbers for your lordship's convenience, my lord.
Yes, Mr. Sanyal, what is your instruction? Have you taken?
We have used our affidavit. We will argue on that.
No, because two plot there is a dispute.
No.
No.
No dispute. According to us, no dispute.
Okay.
No, just. আচ্ছা ওই রিপ্লাই ওটা বার করেছি কি দেখো এই মা আমার এটা কোথায় গেল বলতো না জাস্ট জাস্ট মিনিট মালার আমার নোটসটা কাল কোথায় গেল তুই হ্যান্ড কিছু নাড়লি নাকি
My junior is here.
নোটসটা আছে দে আমাকে দে কোথাও ওর মধ্যে আছে বিল আছে জাস্ট মিনিট মালার আই লস্ট দ্য নোটস ওই দিদিদের যে শর্টস এইটা পাঠালেন না তার মধ্যে লিখেছিলাম সেটা কোথায় গেল কি বই কই আচ্ছা রিপ্লাই করে দিচ্ছি কি হলো then how do I proceed like this no, my learned friend has shown your lordship. I just take your lordships to reply দেখো synopsis পাঠালো না কালকে page 43 then I will take your lordships to the writ petition.
Page 43 of the WPA.
Page 43.
Repetition.
No, of the affidavit in reply used for the drawing, my lord. One.
Affidavit in reply.
আরে ওরা যে পাঠিয়েছিল না না আমার নোটস আছে now your lordships will find there are 3 lots A, B and
Just
C.
a minute, where is it? Affidavit in opposition on behalf of the respondent.
Reply, my learned friends have filed.
Yes, affidavit in reply.
Page. Now your lordships will find there are 3 plots.
Yes.
3 lots rather, A, B and C. Page 43.
Yes, 43.
Well, total area 5 point some hectares, your lordships.
Yes.
My learned friend is already in possession, according to us illegally, because the earlier lease agreement expired. A. That's the most lucrative part of it. My learned friend's case, if I have understood properly, that in pre-query of the bid, we said that we will hand over this exit, egress and the covering of the land. This is Now, my lord, A already in possession. Our case is that he is enjoying this, he is getting fruits of it, he doesn't want to go enter into the lease of agreement. Now I will take your lordships to the our RFP, which ultimately fructify into the lease of agreement. Well, there are 4 stages.
So you mean to say that as on date, there is no dispute and
No
you can,
dispute.
and you can execute that agreement.
Yeah, he is to execute.
That's why if the
That's
petitioner come, you are ready to execute the agreement. There is no dispute at all.
no dispute. I tell you, lords, no. There is no dispute, but we have Malad cancelled the LOA already. Now there are 4 stages. First bid, second LOA, third Malad execution of the agreement. This part he has not complied with. Malad, after execution of the agreement, the question of handing over the land comes, not before the agreement. So he's putting the cart before the horse. We have never said there is no document that we are not in a position to hand over the plot with egress and others. Rather, I will show your lordships to the RFP that points comes up after the execution of the agreement and from the appointed date that will be effective. Now, your lordships kindly take up now the petition itself. That's at page 31. Your lordships, it starts from page 30. I will take some of the provisions of the request for proposal, in short, RFP. Now your losses will find page 31, para 1.2. This narrates what the work is to be done under the execution. Then 1.3, your losses will find the authority shall provide the lessee with the sites at as is where is basis for development of mandatory fuel and non-fuel facilities with work, including but not limited to development of common user facilities such as parking, washroom, etc. In addition to the master plan and site-specific layout, facade design, building construction, HVAC installation, utility connections for water, electricity, which has been made part of the tender documents. Now, the rest I do not proceed. Now I take your losses for your convenience of the court, page 186. My learned friend has placed it. The relevant portion will be your losses, page 187.
Correct.
Pre-bid queries. Point number 2.
Yes.
The RFP mentions that the authority shall provide the lessee, this is query, with the sites at as is where is basis for development of mandatory fuel and non-fuel facilities with work including but not limited to development of common user facilities such as parking, washroom, etc. In addition to the master plan, site specific, all that, which I placed from paragraph 1.3. Now kindly see the reply. The concerned sites are constructed sites which shall be provided as is where is basis.
Yes.
And the authority shall provide the entry and exit access of lanes to WBS.
Yes.
Then WSA. The demised land shall be provided at the level of entry and exit access lanes to the demised land. So we have promised in the pre-queries bid that we will do that.
Yes.
These questions, this is at the time of handing over of the demised land, not before the execution of the lease agreement.
No, unless and until it is not totally, where is that this house will be taken out only?
Exactly. I will show from one after another your losses. All the certain provisions has to be placed before your losses. Now your losses will find page 33, 1.10.
Yes.
Now, my lord, 1.10, your losses kindly see. To obtain first-hand information on the assignment and on the local conditions, the bidders are encouraged to pay a visit to the project site before submitting their bid and proposal. They have done it.
Correct.
And then your lordship prerequisite, now kindly see 1.11. Your lordships will find how the process will be done and the schedule date. Third one is pre-bid meeting date and venue. Keep
It is done.
exactly venue, and that was done. Then your lordships will find page 42.
Yes.
Matlab, point number, para number 2.3.2.
Yes.
The following which are more appropriately described in the enclosed lease agreement are also to be considered in the preparation of the financial proposals. Area of land for lease as per the list. Now point B. The lessee agrees to pay to the authority from the year commencing from the date of construction of facility 8 months from the appointed date. I will take your lordship that this definition in the proposed lease agreement. The date on which the demised land shall be handed over to the lessee by the lessor in accordance with the provisions of the lease agreement. Well, according to me, this makes it clear.
Yes.
The demised land will be handed over after the execution of the lease agreement. My learned friend presumes that I cannot do it. This is presumption. I am in possession of the land. And unless, my lord, I handed over, the point of working will not count. And he is not liable to show anything. I will show that, your lordships. Then, in accordance with lease agreement, a recurring annual rent as quoted in annexure such and such. Malad, this has been shown, Malad, how it is to be paid rents allies. Now your losses kindly come to page 43.
Yes.
Clause E. The authority shall grant the lessee pre-approved access provision to the demised land before the commencement of the construction work. However, even I will show Malad, not even from the appointed day. When the commencement of the work he will occur, then I will do that. No further approval will be required for the authority prior to commencement of construction work unless stated otherwise. Then your lordships, if the lessee shall start the development work on the demised land within a period of 8 weeks of the appointed date, in case it is delayed, the additional charge by a penalty of 2% of the annual lease amount per week will be levied on the next 16 weeks or part thereof, and the lease terminated if construction is not started within 4 weeks from the appointed date. Kindly, my lord, if we read together all these, what happens to that? Construction work will be done from the appointed date. Appointed date, which is, I will show to your lordship the definition clause. And then your lordships, this will be done when the commencement of the works, when I give them access to the demised land. Then your lordships will find clause. Now, my lord, your lordships will find page 44.
Yes.
Well, last point, my lord, para Q, small q. The bidder will bear all duties, taxes, royalties, other levies payable under the laws, rules, and regulations of central government and state government and local bodies. The authority will not reimburse any tax or liability on account. This is not relevant. What is relevant to your loss is the next proviso. Provided further, in case lessee has developed the site within the specified period of 8 months from the appointed date. However, the access of site for the project stage is not available for any specific reason attributable to the authority. This is addressing his difficulty. In such case, lessee shall not pay any lease rent for the duration of the delay attributable to the authority. Suppose lease agreement executed. I cannot give access to the demised land in a certain portion. He is not liable to pay the rent. But this is not the case. What he is doing, since he is possession of A, he is enjoying that.
Yes.
Then your lordships, kindly see the examples given. This is very important, your lordships. For avoidance of doubt, in case the development period of the project is 8 months and the appointed date of the project is 1st January 2022, then the commercial operation date of the project would be 1st September 2022. However, in case lessee has completed the project on or before 31st August 2022, and the authority provides the access of site for such project stage on January 1st, 2023, then in such case, lessee pay the lease rent from 1st January 2023 only. What makes it clear to your lordships? If I can't give you the access, you are not liable to pay the rent. So you will not suffer anything. Then kindly, my lord, this is more clear from the subsequent 2 paragraphs. Moreover, in case lessee has developed the site before the development period of 8 months from the appointed date, and the access of site for project stretch is also available, in such cases, lessee shall pay lease rent from the date specified in the lease agreement, which is 8 months from the appointed day. However, they may be awarded the completion certificate and given the right. Then your losses, for avoidance of doubt, if the development period or development period of the project is 8 months and appointed date of the project is 1st January 2022, then the commercial operation of the project shall begin from 4th September 2022. In case the lessee has completed the project on 31st July 2022, and the authority also provides the access of the project state on 1st August 2022, in such cases also lessee shall pay the rent from the 1st September 2022. All the eventualities have been conceived by the RFP. Having knew all these, he entered into the agreement. Having known all these provisions, then your lordships kindly consider page 52.
Yes.
Clause 7.3. The notification of award, my learned friend bank upon it much.
Yes. Yes.
The notification of award will constitute formation of the contract. Kindly see, subject only to furnishing of a performance security and in accordance with the provisions of clause 8 and as per annexure 4. Then, my lord, 7.4. This agreement will be signed by the authority and the selected bidder as per annexure 3 after the performance security is furnished. The bidder shall sign the lease agreement within 10 days of submission of the performance security, failing which the performance security shall be forfeited.
Yes.
But if we read together, if you do not execute the lease agreement, then the entire thing comes to an end. I will show to that, your lordships. This is only the basis of the contract, LOA. Then your lordships will find page 53.
Yes.
Clause 8.1, your losses will find within 30 days after the date of the receipt of the letter referred to in clause 7.1 above, the selected bidder shall deliver to the authority performance security. He has done it. The lessee shall furnish the performance security for fixed period amount, all that. There is no quarrel about this. What I am pointing out, your lordships, kindly see the next paragraph, last 3 lines. The development period is 8 months. The bidder shall sign the contract agreement within 10 days of submission of the performance security, failing which the performance security shall be forfeited. We have cancelled the LOA only. We have not forfeited that. Then your lordships will find 8.3. Failure of the selected bidder to comply with the requirement of subclause 8.1 shall constitute sufficient ground for cancellation of the award. These we have invoked. And forfeiture of the earnest. The second we have not done. Now your losses will find.
So no forfeiture was done.
No forfeiture done. Only cancellation. Now, my lord, kindly come to page 59. This is format of the lease agreement. Page 59.
Yes.
Now, my lord, I am on, my lord. Kindly, my lord, turn page 60.
Yes.
Kindly see. Appointed date means definition clause of the agreement.
Yes.
Means the date on which the demised land shall be handed over to lessee by the lessor in accordance with the provisions of this agreement. Then kindly see handover. Means the date on which devised land has been handed over to lessee by the lessor, it shall be within 15 days from the signing of agreement. My learned friend's client suffering from an ill-conceived notion that I will not be able to do it. This is my property.
Yes.
So handing over part, Malad, after execution of the agreement. Malad, if your loss, certainly your lordship can put question to me. If after execution of the agreement you cannot hand over the land or demise or access, what will happen? Malad, that's why I have shown to your lordship's clause that he is not liable to pay.
Not to pay the rent. Yes.
So this is not the way, Malad, to deal with the contract as it is where it is specious. This is the first part of the Malad. If your lordship takes it up Friday, my learned friend said, where tomorrow has some difficulties. I shall continue in the first of Muladandi.
Record. The Grand Council for the respondents.
Only one request, your lordships. Kindly take it up in the first half on the first Friday. But second half I may not be available.
No, second half it's not possible.
No, all later. Your lordships
Grand
kindly
Council
keep
for
it
the
in certain
respondents
first
the matter at length,
items.
but argument could not be completed. Let the matter appear on 24 under the same heading.
করলাম Friday.
Friday.
Much. থাকবে থেকে রেখে দেবে
I appear for the
it will be within certain
within 10 minutes.
within 10 much.
Yes.
It's that matter, my lord.
My lord, in this matter, sorry. My lord, in this matter, my lord, I am led by Mr. N. Poddar. He is before court number 16.
Appearing for whom?
Jem, respondent number 5.
Jem. Yes.
That's the main respondent.
Main respondent.
Yes.
But in that case, my dear lordship, may kindly take it up sometimes next week. Tomorrow I've got some availability problems.
Where is Mr. Dasgupta?
Your lordship, I am appearing on behalf of Mr. Dasgupta. He's on his legs in another court. But your lordship, next week, unnecessary, it would be delaying because Coal India is suffering, ECL is suffering, your lordship. ECL cannot publish the final outcome because of the stay, and for that the coal is being deposited. It's the monsoon season; it may get damaged. There are chances of theft, your lordship. That is a primary concern, which is with
What you want? Tell me.
Your lordship,
Your senior is not here. Her senior is not here. So what can be done? In one hand you are asking for the argument, but other hand your seniors are busy in the other court.
Your lordship, can it be fixed a bit earlier tomorrow?
Learned counsel for the respondents are busy in the other court. And as such, the case is adjourned. Let the matter appear on 29 July.
Very
29 under the same heading.
But the interim order may be extended.
Interim order is extended till the next date of hearing.
I'm grateful.
Yes.
Before your lordship rises, may I have lordship's kind indulgence to mention items numbers 12 and 13. And I am appearing for the petitioner in one of the items. But I would beseech your lordship, can these matters be taken up on Tuesday next
12 and 13. You are for the petitioner.
Yes, madam. In one matter I am for the petitioner. In another matter, 13 I am the petitioner, and in 12 I am the respondent number 20. My lord, I have taken the consent of the other side. Can it be Tuesday any time, my lord? My other side was insisting that some time may be allotted because I am seeking adjournment.
Time it will go.
Any time, my lord.
Time 12 बजे कोई है देखो.
ठीक है. Tuesday.
4th August. खाली है. Item number 11, 12
and 13.
12 and 13. Let the matter appear on 4th August at 12 noon.
4th August. But next Tuesday, my lord, not
4th
next-
August.
But next Tuesday, my lord.
Next Tuesday, then time will not come.
But let it be next Tuesday, otherwise my other side will kill me.
Okay. Item number 12 and 13. As per the prayer made by the council for the petitioner in WPF 17068 of 2026, let the matter appear on next Tuesday on 28th July. Under the same heading.
4th August to 12th. Time
Well,
very
item 12:30, my senior has paid for.
Okay, now 29 July.
But only one.
28 July. Huh?
Learned senior friend will be gracious enough to lend a copy of the writ petition to.
That is available in the
No,
Shastra.
no, my lord.
My lord, that
You are
we
appearing
will
for
come
whom?
to that. We'll
I
come.
am the writ petitioner in item 30.
Ah.
My learned senior friend is in the writ petition in item 12. I have implemented him as a party. But
But I am not.
generous enough to.
But I am not,
But
I'm bad.
No, no.
My
Okay,
lord,
okay.
my lord,
My lord বলছি।
Okay, next.
This matter was mentioned on the 18th of June. Your
Ah.
Lordship had been pleased to allow my mentioning and direct the matter to appear within the first 10 matters. But unfortunately, my lord, the matter is appearing item number 32. My lord, if that is not taken up today, my lord, kindly be taken up tomorrow, retaining his position. My lord. That is my humble prayer. This matter is with regard to CWC. Another matter is fixed tomorrow with CWC. We take retaining his position.
Yes.
Grateful, my lord.
Yes, call the matter.
I am for the petitioner, my lord,
111.
petitioner.
Yes.
So today, the matter is fixed at the instance of my lord, and there is one of my application, which is.
Possibly that will not be required because the petitioner has given me a letter, my lord, he does not want to proceed with the matter, my lord, any further. This is a letter given by my.
The interim orders be taken.
That may be 7th of May 2020.
My lord, I am appearing on behalf of the respondent number 18.
Though the matter is specifically fixed today at 2 p.m. for hearing, but the Land Council for the petitioner submission has handed over a written instruction from the petitioner to the Land Advocate on record of the petitioner dated 22nd of July 2026, wherein it was informed that the petitioner is not willing to proceed with the instant writ application. Accordingly, Land Council for the petitioner prays for withdrawal of the writ application. Land Council for the respondent submitted the petition is enjoying the interim order. The interim order may be vacated. In view of the submission made by the council for the respective parties and the communication dated 22nd July 2026, WPA number 1584 of 2025 is dismissed as withdrawn. Interim order, if any, stand vacated. Can is also there.
Mine can is there.
Pending application.
Addition of
Accordingly, all pending applications all disposed of.
Online copy that is not required. Online justifying my presence.
Yes, name will be there.
No liberty to file afresh on the self
No,
cause of action.
No, nothing.
Only withdrawal, dismiss as
Withdrawal
withdrawn.
means that unless liberty is specifically granted, my lord, it's not required. It cannot.
There is no liberty is not.
I am not asking. I am not paid.
Yes. Item.
I appear for the petition.
Lordship, I am appearing for the respondent bank.
Yes.
That means this one the affidavit of service be taken up. That by Mr. Gupta.
Yes.
This is my application. One of the usual matters which comes before your lordship, bank account frozen without anything, without any order from any court. Your lordship would kindly take a look at the first annexure. Only 3 or 4 to trouble your lordship with. Kindly sees the first annexure. This is where the bank intimates me.
Where is the notice to the respondent number 3 and 4? Served?
Served. Yes.
Service?
Affidavit of service file. Your lordship is looking at the affidavit of service, my lord.
Yes.
Yes. Now, if your lordship kindly takes a look at the writ petition once, my lord. Kindly takes page 14.
Yes.
But this, my lord, the bank intimates me when I tell them that why is my account frozen? They say that they had received a complaint and we are acting on the instruction of Cyber Police Station, Navi Mumbai. Your lordship would find that we would like to inform that we have received a notice from Cyber Police Cell, Navi Mumbai, advising and authorizing us to freeze your account number such and such with immediate effect.
Yes.
May I pause here for a moment? This notice has not seen the light of the day so far as we are concerned. They have not given to us despite repeated requests. Now, my lord, kindly turns to the next page, page 15.
Yes.
This is a notice given to me by Navi Mumbai Police Station asking me to appear. Now, the petitioner is a 73-year-old lady. The notice, my lord, will find is dated 28th of January, and we received this after the date of hearing. Second is the date of hearing. We received it on the 3rd. We immediately on 5th say that this notice, that reply your lordship would find at page 16,
Yes.
where we have indicated in the third paragraph that we received this notice on 3rd February, whereas the notice directed us to appear on the 2nd.
Yes.
Well, thereafter, nothing is forthcoming from them. Once again, we write a detailed letter at page 19, seeking what order, how much amount, nothing is being given to us. Straight away, my account frozen. Now, my lord, bank writes a letter at page 28, purporting to give some details.
Page
28, my lord.
Yes.
This is bank's letter.
Yes.
Well, the bank only discloses, my lord, the cyber police complaint case number, which your lordship would find at the bottom of that page. How much amount? Where is the order? Nothing has been given. They only say that it was directed that you freeze this account because there is a cyber complaint case.
Yes.
Now, my lord, we come to learn of a first information report, which was lodged. My lord will kindly turn to page 30.
Yes.
Page 30.
Yes.
Your lordship would find this is the first information report, my lord. This is in, my lord, Hindi, my lord. If your lordship kindly, there's a translated copy, my lord. Page 43 onwards, my lord. May I just indicate, my lord, this is not an official translation, but we had translated this to annex in the petition. But here your lordship would find that a complaint was made by one Vishal Dattaram Pachal, which your lordship would find last line at page 43. Kindly turns over. The complaint is against one Diya Roy, which is paragraph 5 or clause 5 at page 44, and some unknown programmers and operators. And my lord, what is the complaint? Your lordship would kindly come to clause 7. I such and such. Then, my lord, thereafter, my lord, he writes in the second paragraph, I reside at the above. Has your lordship got it, my lord? I reside at the above mentioned place with my family. My Axis bank account number is such and such, Kotak Mahindra such and such, and my wife's name is such and such, and has a bank account. These are my wife's savings account. On my above mentioned mobile numbers, I have a WhatsApp, Facebook, as well as Telegram accounts. Telegram is on the process of being banned because it's getting hacked. Now, my lord, next paragraph. On such and such in the afternoon at, well, kindly sees the date, 5th March 2023.
Yes.
In the afternoon, on my Facebook page linked to account number such and such, a request came to me. When I accepted it, I saw an advertisement regarding investment in shares inside it. Upon clicking that link, I was directly added to one Telegram account in the name of Lucky Girl such and such. Then, well, so on and so forth. The complaint nowhere even remotely mentions anything concerning us.
Yes.
So, my lord, this gentleman has been duped by that site. He clicked on the link. Something had happened. Now, my lord, for that, my lord, there is nothing else to show how am I responsible. Nothing, nowhere, no order. So, my lord, it may so happen that some proceeds of crime, my lord, could have been given, could have come to my account by way of any payment I've received from somebody that may be in different layers. So, my lord, considering situations like this, your lordship has held that, my lord, without any order from court, the attachment or the blanket freezing is bad in law, and your lordship, my lord, directed that to be unfrozen. May I hand up, my lord, Zenith's, what I'm finding difficulty in pronouncing, my lord, Zenixt. But kindly sees the first paragraph, defreezing. Second paragraph, the accounts have been frozen. Then, my lord, all the judgments your lordship relied upon in page 3, my lord, considered all these, my lord, which they relied upon. And, my lord, the bank contention, your lordship would find at paragraph 4.
learned counsel for the respondent bank submits the bank has freezed the accounts of the petitioner on the complaint received through portal of Ministry of Home Affairs. In this case, it's Navi Mumbai police station. On the submission of the learned counsel from the bank, this court has directed the petitioners to impede the Ministry of Home Affairs as party. Accordingly, the petitioner has made Ministry of Home Affairs a party. We have made the Navi Mumbai police station a party also. Now, paragraph 7 at page 3, my lord. The blank has freezed the accounts of the petitioner on the instruction received through portal. As per submission made by the learned counsel for the Union of India, has not received an instruction from the Union of India. In case of such and such, the Honorable Division Bench of Bombay High Court, relying on the judgment passed by Kerala High Court in case of such and such, held that a police officer investigating a crime has to approach the jurisdictional magistrate under section such and such of BNSS to seek attachment of any property believed to be derived directly or indirectly from criminal activity or commission of an offense. Subsequently, courts will have to be adopted in terms of the order passed by magistrate. Support further clarified that while section 106 speaks of seizure, section 107 deals with attachment, forfeiture and restoration. Seizure under section 106 can be carried out by a police officer and an ex post facto report submitted to the magistrate. On the other hand, this is very important. On the other hand, attachment under section 107 can be effected only upon the orders of the magistrate. The logic behind the distinction being that the purpose of seizure is more to secure the evidence during an investigation, whereas an attachment is intended to secure the proceeds of crime by preventing its disposal and thus ensuring its availability for legal procedure such as forfeiture and distribution to the victim. Thus, the judgment makes it clear that freezing account is not permissible under section 106 of BNSS. In the present case also, the bank and the Union of India has failed.
Your Lordship,
Only one fact I should need to inform. But may I file a supplementary affidavit? This happened subsequent to filing of the writ petition. May I just indicate? But they say that your account has been defreezed, unfreezed, but with a lien of 77 lakhs.
With the lien of?
Lien of 77 lakhs.
71 lakh.
71 lakhs or
71 lakh 33,000.
How you got it? 70?
Yes.
How you got that 71 lakh?
My lord, on 1st July from the cyber police station, Navi Mumbai, we were intimated, your lordship. May I hand over, my lord, the email and
Which document, Mr. Gupta? By which document they're telling that the 77 lakh?
Yes, my lord. Your lordship would kindly have a look at page 6, my lord, annexure P7 of the supplementary, my lord.
Page 6.
P6, your lordship will find there's a, in the second table, lien amount. They have not informed me also. I have come to learn. In fact, page 8 is a screenshot from my mobile where I have received an SMS that your account has been unblocked and activated for use. But when I go on to their site and my statement, I'm sorry, the account, I find that it shows a lien amount. So once they are saying frozen, then they send a SMS that unblocked, then they show there's a lien amount. 2 notices served, my lord, pages 9 and my lord 11, no reply.
Yes.
My lord,
what is the particular?
As the instruction given by the Navi Mumbai police station, we freezed the account. After that, on 1st July, whenever we received the email, we then and there defreeze the account. And as by, if your lordship kindly.
Where you got the 71 lakh, which order? Show me.
There is no order, your lordship. Only it has been intimate.
Is here the total question of the code. Show me the document or any evidence that you have got the specific report from the agency or the court that the 71 lakh 33,000 is to be blocked or kept in lien.
The mail we received, my lord, from.
Show me.
I just handed over the email.
So from whom you received?
It is from Navi Mumbai police station.
When you received?
It is received on 1st July.
1st July of?
1st July 2026, my lord. It is stated here in the matter investigation is going on. Now kindly defreeze this account and lien markup rupees 71 lakh 33,000 with immediate effect. Defreeze this above bank account. Your early response is highly appreciated. And after some inquiry, we have defreezed the account and lien mark on the said amount.
Okay.
We have only followed the instruction from the Navi Mumbai police station, my lord.
Okay.
Same thing. Random amount will be intimated. This is where the judgment, my lord.
Who has received, who has given this report to you?
1st July
Who
2020.
has given this mail to you?
This mail,
Ah.
this mail, second page, my lord, please come. Second page, Vishal Patil, Police Inspector, Cyber Police Station, Navi Mumbai.
The petitioner has filed the present writ application praying for a direction upon the bank for defreezing the account of the petitioner. The petitioner is maintaining the saving or current?
But only one.
Maintaining
only
the
one
saving
thing,
account in the respondent bank, but all of a sudden the respondent bank has freezed the account of the petitioner. Freeze the account of the petitioner being account number 1589109439550. Full stop. When the petitioner has inquired from the bank, the bank has informed the petitioner that the bank has freezed the account, and in terms of the as per the information received from the Cyber Police Station, Navi Mumbai, with respect of the CR number 79 of 2024, dated 7th of February 2026. 2026. The petitioner has disclosed the FIR initiated before the Cyber Police Station, Navi Mumbai, on 29th of June 2024 by one series Vishal Patil, Vishal Dattaram Panchal. Then counsel for the petitioner had drawn the attention of this court to the FIR and find that the petitioner name is not in the FIR as petitioner is not the named FIR in named person in the FIR, and there is no mentioning with regard to any transaction with the complainant and the petitioner with respect of the account which has been freezed by the bank. The petitioner has relied upon the judgment in the case of Zenith Technologies Private Limited and others versus Reserve Bank of India and others, passed in WPA number 8458 of 2025, dated 6th of May 2026, wherein this court has held that this court relied upon the judgment passed by the Honorable Kerala High Court in the case of Headstar Global Private Limited, wherein the Honorable Court has held that the police officer investigating a crime has to approach the judicial magistrate under section 107 of the BNSS to seek attachment of any property believed to be derived directly or indirectly from criminal activity or the commission of an offense. Full stop. Subsequently, the court will have to adopted in terms of the order passed by the magistrate. Support further clarified that while section 106 speaks of seizure, section 107 deals with the attachment, forfeiture and restoration. Seizure under section 106 can be carried out by the police officer and an ex facto report submitted to the magistrate. On the other hand, the attachment under section 107 can be effected only upon the orders of the magistrate. In the case the bank failed to produce any order from the magistrate, the bank has acted upon the report of the Cybercrime Police Station, Navi Mumbai. The learned counsel for the petitioner further draw the attention of this court by way of supplementary affidavit that the bank has defreezed the account of the petitioner by keeping an amount of rupees 71,33,000 as lien. When this court has made query from the learned counsel appearing for the bank, the learned counsel he submits that the bank has received an email from the investigating from Mr. Vishal Patil, Police Inspector, Cyber Police Station, Navi Mumbai, wherein he is directed the bank to defreeze the account of the petitioner by keeping an amount of rupees 71,33,000 in lien. Full stop. The petitioner has filed the affidavit of service showing the service of notice upon Mr.
Vishal Patil, respond number 3.
Upon Mr. Vishal Patil, Police Inspector, Cybercrime Police Station, Navi Mumbai, as well as the investigating officer, Cybercrime Police Station, Navi Mumbai. But in spite of service of notice, none appears on behalf of the respondent number 3 and 4. Keeping the above, this court finds that one further opportunity is to be given to the investigating agency to appear before this court and to justify with regard to the keeping the amount in lien. Accordingly, the petition is directed to again serve the notice upon respondent number 3 and 4 by speed post as well as mail. And the respondent number 3 and 4 is directed to either to submit report through an advocate or to appear before this along with the case diary on the next date fix. It is made clear that on the date fix, either if the report is not filed or will not appear along with the CD, appropriate order will be passed. List the matter on 6th of August 2026 under the same heading within 10 matters.
Barring 6th and 7th, could it be any 5th or?
Then 5th of August. Sorry. The petition is directed to communicate this order also to the respondent number 3 and 4.
I'm great. Grateful, my lord.
Next. Yes.
My lord will remember this matter relating to my lord kidney transplantation. My lord will remember my lord passed the order and
who is the donor?
The donor is his friend, my lord, family business, family friend, and they are.
Where is the linkage? What is the proof of linkage of the family friend?
The report has been forwarded by now.
My lord, which is under challenge, that is page number 55.
You satisfy this court with regard to the if it is not a relative or a family friend?
Relative.
Not relative,
Yes.
is a family friend. What is the linkage?
My lord, kindly take the donor affidavit.
Not affidavit. Show the any photograph or anything which can you prove that, or the bank transaction that yes you have a relation for the loan or whatever it is. Otherwise it is not possible. One matter is fixed. I will not pass any order for deciding that issue.
My lord, kindly
Mayor and affidavit will not serve the purpose, then this court has to adjudicate that.
Yes, my lord. The fact is that, my lord, there is in my petition there is annexing of judicial affidavit, which is
maybe
yes. That's the requirement. If my lord wants to inquiry about that, my lord, that is, my lord, kindly take the reason order passed by the authority.
Where is the
absence of my lord's order?
Where is the order?
Page number 55.
Huh?
Page number 55.
Yes.
My lord's, in pursuance of my lord's earlier order, which is annexed to my petition, page number 52. In pursuance of my lord's order.
The same petitioner?
Yes, yes. Because of that, the rule is very specific. The authorization committee ought to publish their reason order within 24 hours. May I read the rule, relevant rule, my lord?
Let's first bring where is the authorization, this order?
Order page number 52.
Page 52?
Yes, my lord.
Yes.
The petitioner has filed the present application praying for a direction upon the respondent authorities, particularly direction of medical education and the authorization committee, Government of West Bengal, to consider the request of the petitioner for grant of approval for the renal transplantation of the petitioner who has been diagnosed
52.
with page number 52. Lordship, my lord.
No, where is the impugned order?
Impugned order, page number 55. It is a complete non-speaking and non-suppliance.
After receiving the district level verification report along with the police verification report duly signed by the SBO. Please before the board meeting. but was rejected on the ground the adverse report police. Adverse police report.
Yes.
Then the file was sent to the legal cell for opinion, and the legal cell opinion is totally unfavorable. And there is a specific objection regarding involvement of financial transaction of the middleman. Then the state authorization committee rejected the donor on the basis of the adverse PR report and opinion. Therefore, you are verbally informed. Yes, where is the report?
My lord, can you report page number 10, my lord?
I might not get the.
Lordship, it's okay to report the.
Give the report.
My lord, kindly have a look. Paragraph number 2, 3, last paragraph. Paragraph number 3, lordship, kindly.
Page?
Page number 10, my lord, of our report.
Who has given this report?
Report.
That is signed by one Dinesh Kumar Singh as
Dinesh Special Branch of Chandanagar PS.
What is the report?
That is paragraph 3, lordship, kindly. Have a look. During local inquiry, I came to know that the donor, Mr. Mithun Nag, has no fixed work. He used to work is a daily basis labor at the different places, has got the chance, and the legal guardian, his wife, Mamuni Nag, is doing the stitching work in Nighty factory and earns about 12,000 per month. Donors' parents are the senior citizen and suffering the various diseases due to their old age, and a big part of their earnings goes in their medical expenses and their daily needs. So it is ascertained that neither donor's family income nor the savings, after scrutinize the bank statement, could be affording the more medical expenses which will be added after this organ transplantation. Therefore, the above noted circumstances, the donor could not produce any documents or relevant fact to ascertain the friendship relationship with the recipient, and as per his family income, he could not afford the pre and post medical expenses by his own. So it is apprehended that the involvement of the middleman and monetary transaction in this organ transplantation.
Yes. Yes, then
Next paragraph.
এটা বললাম তো বলেছি
Then
at the time of inquiry they came to know.
Correct. Then
And there was no financial at page 5, my lord. Page 15 also, my lord, kindly have a look. Page 15.
Yes.
It is 5th May 2026.
Yes.
This is the input order, which is annexed with
What is the duty of the authorization committee?
But may I place this?
What is the duty?
Authority gone for inquiry, and they found that they have no
inquiry.
Pardon?
Who gone for inquiry?
Medical Director of Medical Board.
Huh?
Director of Medical Board.
Where is the inquiry report? Where is the evidence? They have examined the donor and the recipient. Where is the proceedings of the committee? They have called the recipient and the donor, examining the both. Keeping aside the report, leave aside the report. You know how the police is giving the reports. What is the authentic authorization committee will do? What is the duty? You are having act. You are having the act.
At present, I don't have.
You're not arguing before the High Court.
I don't have act.
You are arguing before the High Court. What is the rule? See, what is the rule? See the rule. What is the duty? In which section the duty has been prescribed? See. Merely you are appearing on behalf of the state. One letter is produced. Yes, this is a report. Without going to the law.
Section 3, my lord, says that.
Come ready with the total and satisfy this court what your authorization committee has done. After receipt of the report, only simply by signing will not do. When you will come, go through the total act, rules, what is the duty of the authority and what is to be considered by the authority. When?
Next Monday.
As per the prayer made by the council for the respondent has filed the report, but the respondent failed to satisfy it whether the authorization committee has conducted any inquiry by examining the recipient and the donor. According to council for the petition, prays for time. Let the matter appear on 28th under the same heading. Next. Yes.
Yes, item 16, my lord, I appear for the writ petitioner.
Yes.
My lord, kindly see, my lord, my lord's last order dated, my lord, 16th of July.
Yes.
This also, my lord, this matter deals with the self-same act like the previous one.
Correct. Yes, what is the linkage?
Maybe 5 minutes. Examination report. There is a pen drive.
My lord, what fell from your lordship on the last occasion was the interview of the donor, whether it was videographed by the authorization committee.
So what is the report? What is your you are appearing, you cannot guide your junior or your senior, whatever it may be, earlier matter.
I told that, my lord, that the link has not been proved and the earlier case also. And there is a middleman also involved in that case.
In which matter?
With the earlier matter.
So that's why you see, only getting the police report, you cannot file the report. You have to ascertain whether the authorization committee has to examine all. Yes.
Page 10 of the report, my lord.
Which?
It has fallen from your lordship, my lord. What is the link?
Yes.
Kindly have a look at page 10.
Page 10.
Yes. Of the report which is pursuant to your lordship's last day's order. This is, my lord, general information.
Recipient is Chintu.
My lord, kindly comes to the next page. I showed page 10 because there's a continuation, which is more important. Present, Chintu Kanra and donor Mrs. Rupa Shaha.
Yes.
Main points of giving are as follows. Whether there is any commercial transaction, nothing established. Whether any pecuniary promise has been made to the donor or any other person,
Not established.
not established. Now, my lord, the third point is your lordship's query. Nature of link between non-related donors and recipient.
Yes.
As per verbal statement, husband of the donor worked as a driver, but he is missing since January 2025. General diary has been done by the donor. Now, my lord, directly comes. So, how donor come to contact of recipient? Same thing as per verbal statement. Husband of donor works as a driver, but he is missing in January 2025. General diary has been done. Now, kindly come to the footnote. It is not clear how both the parties came in contact and became friend or driver. No documentary evidence or any photograph was produced. Hence, link between both the parties could not be asserted, hence not recommended. So this is your is answering your lordship's query. Now, if your lordship kindly takes up the repetition, only one paragraph I must show. What is their statement with respect to the link of the relation, paragraph 8 at page 6.
Yes.
Your petitioner states that the petitioner's family member is searching of a donor person who can voluntarily donate one of his or her kidney for the petitioner husband. Finally, pro forma respondent number 7 headed, namely Rupa Shaha, a family friend of the petitioner's husband, voluntarily agreed to donate one kidney to the petitioner's husband out of natural love and affection. I stop over here, Miller. So, Miller, it is the contention of the recipient that is a family friend. That link, Miller, was already not established before.
एक तो बुक तक बुक बताइए, यहाँ से बुक लेने से कहाँ चले जाता है आप लोग?
And my lord, your lordship has already seen the affidavit, which is before your lordship. The affidavit of the donor at page 47. 47 and 47 to 49, my lord. This affidavit, my lord, also does not disclose.
Yes, that I gone through.
My lord, this is the query which fell from your lordship. The report is now before your lordship. Why there is no link? The answer, my lord, perhaps not clear to you.
Yes.
So there is, my lord, with deepest respect, a contradiction in the pleading of the petition and the report. Now, link has not been established. These are my humble submissions, my lord. I do not intend to make any further submission.
Yes.
But may I respond? My lord, the page that has been shown to your lordship, which is page 10 of the new report, my lord, that was already shown to your lordship because this is also a part of the previous report that was filed by the state. My lord, kindly see, my lord, the document that was shown where it has been recommended that my case will not go through. My lord, serial number 3, my lord, they in serial number 3, my lord, of page, this is I think page 10 of the new report.
Yes.
Well, there is a box present Chintu Khara and
Yes,
donor
yes.
Rupa Shaha.
Yes.
Well, serial number 3, nature of the link between non-related donors and the recipient. Well, the comment of the department so far as serial number 3 is concerned is completely irrelevant to establish the link between the donor and the recipient.
No, that's why nature of the link not related as per verbal statement. So the donor has to give the statement what he has stated in the affidavit that is totally contrary to the statement made in here before the authorization committee.
But kindly see then the affidavit.
You have made the your statement before the magistrate on affidavit that you are a family friend, you love due to love and affection, you are ready to donate your organ to so and so.
Yes.
Correct.
Yes.
But that's why I am again and again asking what is the duty of the authorization committee. That's why I called for the CD. Whether the authorization committee has examined the donor and recipient with regard to establish, okay, as per the judgment which you relied on naturally. If it is not a family, not a friend, not a relatives or totally a family friend, only has a friend, if we are not having any documentary evidence to prove linkage, but from the statement has something is to be proved.
Yes,
so, but you have not stated before the authorization committee that yes, I am knowing so and so, but you stated something else.
But that is the department's recording.
Yes.
But kindly see, my lord, the affidavit that is filed by the my lord, donor. My lord, kindly see page 47 first of my writ petition.
Yes.
Page 47, this is the affidavit affirmed before the magistrate. Page 47 is the affidavit of the donor.
Correct.
My lord, kindly see, my lord, page 48.
Yes.
Kindly see, my lord, paragraph 3
Yes.
at page 48.
Correct.
That I would like to donate my kidney to Chintu Khara. But this is the, and kindly, my lord, next sees, my lord, paragraph 4, that I have been thoroughly informed about the potential consequence of my kidney donation, including kidney failure, infection, bleeding, side effects of therapeutic insufficiency, surgical complications, anesthetic complications, and even the risk of death during the operation.
Correct.
That I am donating my kidney to Chintu Khara, son of such and such, out of compassion,
Correct.
without any pressure or financial consideration, solely to save a needy person.
Correct.
That I have been explained and fully understand that the kidney that I am donating may or may not serve useful purpose for the recipient. Now, this is an affidavit just to demonstrate that, my lord, on account of own will and volition, the donation is being effected.
Correct.
But this is not the end, my lord. Kindly see the, my lord, page 50. This is the affidavit of the donor's father, because, my lord, the husband is missing. So father, my lord, in this case becomes the natural guardian. Kindly see, my lord, page 51. Page 51, paragraph 6 at page 51, that by virtue of this affidavit, I am expressing no objection to the donation of kidney by my daughter Rupa Shaha, daughter of such and such, to Chintu Khara, son of such and such. But father, the donor affirms an affidavit, says I am giving it by own will and volition. Father of the donor says that yes, I am aware of everything. I know the pros and cons and the consequences. I do not have any objection. Now, my lord, so far as your lordship's query, kindly see, my lord, rule 23. What is the scope of adjudication or the exercise that the authorization committee will perform? Rule 23 of the transplantation of human organs and tissue rules, Rule 23. The most important part of the rule, which as far that I've seen, my lord, kindly see, my lord, Rule 23, Sub-Rule 1, Roman 4. The consent that the authorization committee.
Rule 23.
Yes, my lord, Rule 23. My lord, kindly see page 29 of the book.
Yes.
Rule 23 is decision of authorization committee.
Correct.
Sub-Rule 1, thereafter lordship sees Roman 4.
Roman for all the interviews to
be video recorded.
Correct.
The video recording is an essential element so far as the recording of the decision of the authorization committee is concerned.
Correct.
Because the video recording will record the consent of the donor.
Correct.
Whether, my lord, the act, my lord, the scheme of the act is that, number one, my lord, it has been framed or, my lord, introduced, my lord, to eradicate commercial dealings in such type of transplants. Because, my lord, the Supreme Court has also said so. My lord, kindly see what the Supreme Court has said in Kuldeep Singh.
Yes, they have given this pen drive.
Yes, my lord, that pen drive, my lord, also records the consent of the donor. And, my lord, Supreme Court, my lord, has said in 2005 in the Kuldeep Singh's judgment, the very purpose for which the act was formulated was to eradicate commercial dealings.
Correct. That's why.
Here, my lord,
that's why this court is also why this court is making query.
Yes.
The court is making query with regard to this should not be a commercialized.
Commercial dealing, absolutely.
Correct. Commercialized. So not a commercialized might be in between the relative also it is commercialized, but it is a between the family. The act provides that is not there. But here if it is not a family friend, family relatives and all these things, then the linkage is to be proved.
Yeah. This is the case of non-near relative. The Madras High Court judgment that I have cited on the last occasion, says in clear words that it is not possible because kindly see the practicality.
But the Madras High Court has not considered this with regard to how the linkage is to be proved.
Kindly see the judgment once again. It has considered rules.
Once you come to the
yes, kindly see the Kuldeep Singh once.
Yes.
Paragraph 9. Kuldeep Singh is 2005.
So otherwise, what will happen? Tomorrow, all the person will go and file an affidavit, and you know how the affidavit is executed before the executive magistrate. It is only the Peskar will take and put the seal of the magistrate. He will not. It is not the statement on oath.
But here, Malad,
that's why on that last day I requested to whether the same statement is given, then it can be a corroborative. Yes. So the court can say yes, it is a corroborative and it can be relied upon.
Absolutely.
But this neither donor nor recipient has given the same verdict, same statement before the authorization committee.
But the statement that has been recorded is that the donor's husband worked as a driver. I don't know what happened on that day when these statements were recorded. But so far as my understanding goes on so far as this document is concerned, the recording perhaps is not germane or relevant for the issue. Because the question that was put across was with respect to the link between the donor and the recipient. What has been recorded is regarding the whereabouts of the donor's husband. But since the donors...
What he stated that was recorded because
yes, that is recorded.
Cannot record so moto. What the donor or the recipient has stated that has been recorded.
Yes, I understand that, but to eradicate the issue, the first stumbling block that I could have faced is commercial dealing. That has been eradicated because here there is no commercial dealing, no middleman involved. Now, kindly see what Supreme Court has said, but because this is an issue of non-near relative. The linkage is very easy to establish between a near relative where the blood relations established. But here kindly see paragraph 12 of the Kuldeep Singh judgment. Paragraph 12, which is at page 127 of the report.
Yes.
Yes, kindly see, I'll just place that. This portrays the scheme of the act. Where the donor is not near relative as defined under the act, the situation is covered by subsection 3 of section 9. As form 1 in terms of rule 3, it shows that the same has to be filed in both the cases where the donor is a near relative and where he is not so far as the recipient is concerned. Now, in case the donor is not a near relative, the requirement is that he must establish that removal of the organ was being authorized for transplantation is the body of the recipient because of affection or attachment or for any special reasons to make donation of this organ. So, it depends on the volition of the donor itself. Now, kindly see, as the purpose of enactment of the statute itself shows there cannot be any commercial element involved in the donation, The object of the statute is crystal clear that it intends to prevent commercial dealings in human organs. The authorization committee is therefore required to satisfy that the real purpose of the donor authorizing removal of the organ is by reason of affection or attachment towards the recipient or for any other special reason. Such special reasons can by no stretch of imagination encompass commercial elements. Above being the intent, the inevitable conclusion is that the authorization committee of the state to which the donor and the donee belong have to take the exercise to find out whether approval is to be accorded. Such committee shall be better in a position to ascertain the true intent and purpose of the authorization to remove the organ and whether any commercial element is involved or not. They would be in a better position to lift the veil of the projected affection or attachment and the so-called special reasons and focus on the true intent. The burden is, I mean, this is very important. The burden is on the applicants, that is the donor and the recipient, to establish the real intent by placing relevant materials for consideration of the authorization committee. Where there exists any affection or attachment or special reason is within the special knowledge of the applicants and a heavy burden lies on them to establish.
Correct.
Yes, I understand. This is the law.
That's the court is telling.
Yes, but
that's I am since beginning I'm telling. Okay, for this purpose you have executed the bond.
Yes,
you have executed an affidavit. You have executed an affidavit before the magistrate. But it is the duty of the authorization committee to ascertain.
Yes.
So okay, authorization committee, one way you are free that there is no commercial
dealing.
With regard to the relation, love and affection. So they have, I don't know what question has been put and what has been recorded.
Yes. But I think
so that's why authorization, before the authorization committee, if your client or if the donor or recipient has given the same verdict, same statement, then it would be a corroborative evidence.
May I say this, my lord? I think the grain from the shaft can be pulled out, my lord, once my lord, the video recording is my lord, seen.
এটা আছে কি? तो चलेगा?
If anyone has a laptop, it can be.
लेकिन लैपटॉप है मेरा तो ना तो मैं चैम्बर से लैपटॉप
But I have a laptop.
लैपटॉप में लगा के
So kindly gives me one each. Yes, my lord, is just now first one. Pen drive.
give it to my court officer. Can your system can be given to you?
Yes, yes, yes. My junior's laptop. My lord. Pen drive to pen drive. My USB device can be connected.
No pen drive.
Yes, yes.
No pen drive.
No pen drive. Achha.
She don't know.
There must be a USB port in each and every. अच्छा जाबे ना
नहीं होगा तो मेरा सिस्टम लेके नहीं वो पूरा नहीं देगा you will give the total
কি দেবো দিন আমি করে দেবো अच्छा
प्ले करो
The neighbor আমি দেখে দিচ্ছি দেখি
नहीं होगा
No, there is no USB port.
दूसरा पोर्ट है बताओ तो
No,
USB
this
port
does not have a USB port.
तो उसमें कोई में भी नहीं आएगा उसमें आएगा लेकिन फिर तुमको सिस्टम बंद करना Live off करो.
But even my lord, I think your lordship's desktop has a USB port.
USB.
CD.
CD will not be there. CD time. is
Your
over.
lordship's my lord, computers, my lord, the desktop, my lord, the
बंद
cabinet, it must be having a
Online
USB
बंद
port.
करो. Live बंद करो.